We plan to mention lots of appeal pay you. Appeal pay you lots of time.
I don't know if you mentioned your lordship. I have filed an IE for change in nomenclature. The trial. This is a special statute matter. This is a special statute matter.
What matter?
Special statute under Prevention of Corruption Act. Your lordship, I filed an IE for change in nomenclature. A writ petition was filed. Now I want to file a CRLMC petition. In this case, there were 3 petitions were filed, your lordship. 3
It is assigned to our bench.
Yes, your lordship.
File that. Yes. Let's say criminal appeal bail. Give it.
But this is an application filed by the Union of India challenging the order of the OM Island. Application filed by Union of India challenging the order of the OM Island. Specifically, this is adjourned to 29/10/2025, my lord. Lord, this is due to emergency.
Please give it.
May I please your lordship, this is a pensionary dues and
Please give
but the last years we could not credit.
Please give it, ma'am. Yes.
More than 12 years in custody. Another memo, modification of bail has been allowed, but the period is not specified.
I have given terminal benefit of senior citizen. Sometimes I have given plea.
This double pitch number 13139/2024. This matter is covered to my lord's judgment dated 2nd July 2025, my lord. This matter was before my lord before vacation. It became out of this time. Making mention to enlist. The matter relates to case of senior citizen. Matter relates to grant of financial operation under SCB scheme, my lord. The case is covered to the scheme itself.
Appeal will custody since 16/8/22. Applicant is the only member.
Bail matter.
Yes, sir.
Please give it. Give it. Give it. Another.
Speak please louder.
Please little louder. These are all bail matters you are mentioning. Please give the memo.
I have filed for interim bail.
Give it.
We can let them or not, please.
What is your matter?
Bail matter.
My lord, I have for bail. It is not more than constitution 10 years.
Please give it.
My lord, item 7 from the list. Item 7 from the list on behalf of Mr. S.B. Jaina, my lord. For the petitioner, I pray for an adjournment. Next.
Item 7.
Is there any interim order?
No, ma'am.
You sought for an adjournment on
79.
79 to again surface here. Why are you mentioning this matter? 21 no central and executive. Okay. Land Council. What is your good name, Land Council?
Swayam Prabhu Jaina.
Mr. Swayam Prabhu Jaina, Land Council appealing for the appealing for Mr. S.B. Jaina. S.B. Jaina. Land Council for the Union of India, 6 adjournment. On 79/2025, also similar adjournment has been taken. Put of this matter. This is Lamba Yes.
The item 40 on today's list, my lords. Bank is seeking 1 week time to file the counter. It's ready, my lords.
Which item, ma'am?
Item 40. 40.
40.
I've informed the other side also. Mr. Rao is here. My lord, the stay is operating against us. So we'll file the counter in the course of the day, let it come up after a week or so. I've informed Mr. Rao.
You are appealing for which opposite party?
My lords,
Because
my lords.
There are
1 and 2.
1 and 2. Achha.
My lords, the counter is ready. We'll file it today.
AD not received from OP number 3 and 4.
That is the husband and children of the petitioner. There is a stay operating against the bank. It's a surfacey matter.
Which order stay has been granted? Okay, that is order dated 79/25. Have you informed Mr. Rao and Nancy?
Yes,
I'm there.
I had informed.
So, how much time you want?
Today, count will be filed today.
All right.
And
Grant me some more time for filing the rejoinder.
Mamata Tripathi, Land Council, appearing for the State Bank of India, Raised Assets Recovery Branch, Madhupatana, Cuttack, submits that during course of the day, she will file the counter affidavit, serving a copy on the Land Council for the petitioner, and therefore the matter may be adjourned to some other day. Mr. S.S. Rao and senior advocate is present in court and submits that if the counter copy is served today, we may likely to go through the same to see whether filing of any rejoinder affidavit is necessary or not. The matter may be taken up after 2 weeks. Because this matter in the phase 13. So let it come then on 3rd November or 10th November. We commencing from 10th November 2024.
Like,
Interim order dated 79/2025, passed in IA number 14403 of 2025. Will continue till next stage. Yes.
Item number 10,
10. huh?
item number 10. I have filed a caveat petition. So Mr. Patnaik has not served copy to me yet recently.
Item number 10.
10. I have.
You have received the copy of the writ petition. So what do you want now?
Mr. Patnaik told me today soft copy, let it come next week.
He has not served a copy.
No.
What is your good name?
Janmijay Das.
Please give it in writing. So and so Land Council appearing for the caviter submits that he has been assured by Mr. S.N. Patnaik, Land Council for the petition, to serve a copy of the writ petition on him during course of the day. And the matter may be taken up on some other day. Put of this matter in the week commencing from 27th of October 2025. In order to obtain instruction. You some other day in order to obtain instruction. So it will be listed on 20 week commencing from 27/10/2025, indicating the name of the Land Council for the caviter.
Weekly list, item number 1.
Your Lordships, I appear for appellants in this matter. Your Lordship, I seek today's time to file the Wakalatnama and the memo of parties. Your Lordship, the
Yes,
Wakalatnamas are.
Wait, ma'am, please. Oh, so. The fixed court order is a large X. Just a minute.
Last order is towards
Last order.
services completed.
24/9/2025.
Services completed.
Land Council states submitted as per the order so and so steps have been taken by the inspector in charge of both police station for service of notice and so and so. But will take up some other date. Okay. Appearing for this one, she'll file local now for the legal year, so is now date and the order dated so and so. We have some remark or duty has been permitted to be solicited in her face. You will file a Wakalat now for OP appellant number 2 and 5. Okay. So far as appellant number 4 is concerned, since he is residing out of country, steps have already been taken, matter will be taken up after so and so. We file Wakalatnama for okay. The undertakes to file a consolidated cost at of the appeal property. State Council shall produce the compliance report regarding service of notice. Okay, first I will ask you, Land Council for the state, have you filed that compliance report regarding service of notice on R5, R6 and R7?
My lord, the let the notice will be served on the sort of 5, 6 and 7.
Yes.
So for 5 is concerned, they have received the notice and they are as per order of, they are stating that we can file the Bhoklanama for opinion 2 and 5, that paragraph, second paragraph.
So for 5, they will be filing Vakalatnama. That's what it says. Madam, you want to file Vakalatnama for which respondent?
Respondent number 4.
What about
Appellant
5?
4, your lordship, appellant 4, not the respondent, the appellant 4.
No,
And for the
File the
appellant.
Bhoklanama for appellant.
Appellant, you are for appellant.
And not 5.
Yes, your lordship.
अच्छा
Rajendra Datta.
Vakalatnama file करो. See.
See, can do.
LRs for ना.
This is for
LR.
respondent number. Respondent number.
No, appellant LR भी file करो. Second paragraph देखो.
No, that
After appellant
is,
submits that,
we
he
are
will file
asking
Vakalatnama.
first about this respondent, then we will go to the
Respondent
appellant.
service.
So service at कौन हला?
Yes, madam. So for the open number for respondent 5 is concerned, they have received the,
Hey,
6 and 7?
and 6 also received, because there are 3 respondents, one is staying in the Kotak Lalbagh police station.
shoot you mo service चलाना नहीं कौन?
Uh,
Report
5
लाल
and 6 services, 7
7 received. And the appellant has to file Vakalatnama and 7 has to be served.
तो 5 पे मतलब जो appellant कोई फाइल करिए पे हो सकता है, paragraph 2 पे. We will file the Bhoklanama for appellant number 2 and appellant number 5.
4. The
Yes,
appellant
sir.
of
respondent
Four.
number. Wait. Respondent number 5. Respondent number 5 वाला के? Rabindranath. और respondent number ये तो अलगा ना लिखाई छी?
नहीं राय सत्यकाम
नहीं, respondent number 5 होता है.
Your lordship, appellant number 4 is Jyotindranath Rath. And
Consolidated कहीं थे ये रहा.
ये
What is that consolidated?
लिखा है
Where is the consolidated cost title of the appeal memo?
your lordship will file it today in the due course of the day. Actually, the Vakalatnamas has reached Cuttack, but we'll file it today itself. Due to curfew, it could not be delivered on time to be able to file it.
What is that?
We will file both of it in the due course of the day.
Mr. State Council, if you see this writ appeal cost title, in the writ appeal cost title, respondent number 5 name has been given as in handwriting. It is Brahmarabara Seth. Respondent number 6 is Maheshwar Nayak. And respondent number 7 is Prabhakar Nayak. देखिले आपनों की दिन आदि
पुना ये अनुसार नोटिस दे थोड़ा
80 देखो ना
रीट अपील रो who is the respondent number 5, 6 and 7? What is the name of those 3 respondents?
Your lordship, respondent number 5 is Brahmabar Seth.
Brahmavar
Respondent-
Seth. Then what is this? It is mentioned here in this that respondent number 5, namely Rabindranath Datta.
Your lordship, they are the appellants.
Rabindranath Datta is appellant.
अरे लिखा ही
It is not the appellant number 5.
हाँ, but what are you doing this?
Appellant number 5 is Rabindranath Datta.
Yes, your lordship.
No, ठीक में confusing.
आपको रेस्पोंडेंट को सर्व करे वाला appellant को थोड़ी
handwriting अच्छी.
सर्विस करे पूरी And she has to file Vakalatnama for 4. Appellant number 4.
Yes, your lordship.
Jyotirendra
ये जो 5, 6, 7
service
सर्विस ही नहीं सही थी पाई क्लोजिंग रखा हुआ नहीं अपना तो नहीं होना मीनाश्री महान who is मीनाश्री
Appellant, your lordship. Actually, the appellants have received notice instead of the respondents.
6 number Meenashri Mahanti. Appellant number 6.
पण आपण कोण करूचंदी मु have you not gone through the order
ଆପଣ ରେସ୍ପଣ୍ଡେଣ୍ଟ ଜାଗାରେ ପିଟିସନ appellant କୁ ସେର୍ଭ କରିଦେଇଥିଲେ
So matter the letter was sent on that name, that's why
ହଁ ସେଇଟା problem.
go IAC, go come.
ଆପଣ
3 orders have been passed one on 18/8/25 then on 8/9/25 and last order is 24/9/2025
so was the letter which you have written. Let us understand what you have written.
That's why
the order is very clear that notice has to be served on respondents number 5, 6 and 7
ଆପଣ କଣ ଲେଖିଛନ୍ତି letter? ଦେଖୁନାହାନ୍ତି ଏଇଟା ଲେଖିଛନ୍ତି ସେମାନେ କରୁଛନ୍ତି ଠିକ କରୁଛନ୍ତି ଆପଣ
that Mr. Goyal. If it come next week, we can all this plan.
ଆପଣ ଇଏ ପିଟିସି appellant ମାନଙ୍କର ନାଁ ଲେଖି ଦେଇଛନ୍ତି
That's
ସେ ସର୍ଭେ କରି ପଠେଇଛନ୍ତି ଆଉ କଣ ଗଲତ ପୁରା
and you see the affidavit which you have filed. An affidavit has been filed by the inspector in charge of Gop police station. That is at flag G.
that is also
Huh?
personal 5 is where that
अरे अपना अपना आमे कोइलु रेस्पोंडेंट को नोटिस करन तू सर्विस करन तो आपण जाई अपेलेंट को सर्विस पर अपेलेंट पे काउंसिल अछंदी Are you having the copy of these 3 orders 18/8/25 8/9/25 and 24/9/25 18/8/25 पर page 2 को आसन page 2 रो लिखा है in view of the order of the Honorable Supreme Court, Learned Council for the State accepts notice on behalf of respondents number 1 to 4. पाइले तापर लाइन टा देखो registry shall issue notice to the respondent number 5, 6, 7 by day after tomorrow, fixing the dates so and so. The notice shall be served on so and so through the inspector in charge of Gop police station and compliance report गला तापरे आपन को next order टा मध्यम very clear जोटा order dated 24/9/25 रे सेटा मध्य operative portion देखंतु last पूरा जोटा page 2 रे अछि Learning Council for the state shall produce the compliance report regarding service of notice on R5, R6 and R7 आज कौन बुझीबार कौन असुविधा ला आपण अपेलेंट को कौन लेकिन सर्विस कर देले नोटिस
ଚିଠି ଲିଖିଛନ୍ତି ଏମିତି ଆଉ ସେ କଣ
even though lekon as per the order of the Honorable Supreme Court in civil appeal number 8073 of 2024 specific order was passed on 18/8/2025 to serve notice on the respondents number 5, 6 and 7, namely Ramaravara Seth, Maheshwar Naik and Prabhakar Naik respectively through the inspector in charge of Gop police station and to produce the compliance report regarding service of notice on those 3 opposite parties and the learned counsel for the take time for such compliance. Which would be evident from the order, subsequent orders dated 8/9/2025 and 24/9/2025. But it seems that from the office of the AG, instruction was issued to the inspector in charge of Gop Police Station, Puri, to serve notice on appellants number 5, 6, and 7. And accordingly, service notices on appellant number 5 and 6 have been filed today. There was no order passed by this court to serve notices on appellants number 5, 6, 7. And therefore, the instruction that was issued to the inspector in charge of Gop Police Station by the learned additional government advocate is a total non-application of mind. Mr. Naik, learned additional government advocate, however, submits that since inadvertently communication has been made from the AG office for service of notice on appellant number 5, 6, 7 instead of respondent number 5, 6, 7, he may be given some more time to carry out the order dated 18/8/2025 passed by this court. Put up this matter on 27 October 2025. The Land Council for the state on that day shall produce the compliance report in that respect. Stop. The what is your good name, madam?
Shruti Aradhana.
Shruti Aradhana, Land Council for the appellants. Okay, so far as you are concerned, you on 24/9/2025, you made a submission that you will file wakalatnama for the legal heir of appellant number 1, whose name is Kumar Horojyoti, and he has been permitted to be substituted in place of appellant number 1.
Your Lordship, as far as appellant number 1 is concerned, he was substituted before the single judge wide order dated 10/11/2022.
Acha, okay. So far as appellant number 2, Rabindranath Datta, appellant number 5, Ratindranath Datta are concerned, you also said on that day that you will file wakalatnama. Have
Your
you
Lordship,
filed it?
Your Lordship will file it in 2 days' time. It was delayed because of the parcel could not reach us due
Right,
to the curfew. We will file it
the-
in 2 days' time.
May I premium let the consolidated court title may be solved because they are giving the address that in the main file that is in the handwriting address, but we don't have that address.
We will file the same along with the wakalatnama.
The Learned Council, Shruti Aradhana, Learned Council submits that within 2 days, she will file wakalatnama for appellant number 2, Ravindranath Dotto, and appellant number 5, Ratindranath Dotto. And on that day, 24/9/2025, you also submitted that you will file wakalatnama for appellant number 4, Jyotindranath Dotto. What happened?
Your Lordship, Jyotindranath Ratha is appellant number 5. Appellant number 5 is Ratindranath Ratha, and appellant number 4 is Jyotindranath Ratha. Jyotindranath
Madam,
Ratha is
appellant number 2, 5 and 4. ये समस्तଙ୍କ ପାଇଁ ଆପଣ वकालतनामा फाइल କରିବାକୁ କହିଥିଲେ, that has been reflected in the order dated 24/9/25.
Your Lordship, there was a small mistake in understanding because of the cost title. Respondent number 2 and 5 is pending, and 2 is filed, 4 and 5 are pending. These two we will file. 4
You
and
file
5
it,
being
otherwise we will
Jyotindranath
dismiss on the
Ratha.
next day. We'll dismiss it on the next day. And also consolidated cost title during course of the day. You serve a copy on the London State Council.
Yes, Your Lordship.
The consolidated cost title shall be of the appeal memo, incorporating the substituted appellant number 1, shall be served on the Land Council for the state during course of the day. Wakalatnama for appellant number 2, 4 and 5 shall be filed by next week, failing which the writ appeal shall stand dismissed without further reference to the bench. Yes, next.
Item 2.
May I please, Madam? By filing this petition, the petition has challenged the order dated 2nd April 2025, dismissing the original application by the Law Tribunal, my lord. That is Annexure 13, page 56, my lord. Para 9 is the operative portion of that order. Page 64. I am placing para 9. In the instance case, obviously and axiomatically, the applicant got
Where is the original application?
I have already filed along with a memo and saw a copy on my learner file.
What was the prayer before the Land Tribunal?
My prayer quoted at page 59 in the infant order.
To pass the order dated 10/3/2017 and 6/3/2018, the annexure A/4 and A/7 direct the respondents to grant third financial upgradation under MSCP scheme with effect from so and so, and direct the respondents to grant consequential financial benefit, area salary, so and so, with 12% interest for the delayed period. So that was the prayer which was made by you before the London Central Administrative Tribunal. Okay, and they filed the counter affidavit, or where is the copy of the counter affidavit?
Annexure 12, my lord.
Annexure 12. So what stand they taken?
They have taken, my lord, that as because my first and second promotion are ad hoc, so I am not.
Show those lines.
My lord, page 51, my lord.
51.
Page 3. The internal page 3 of the counter. Running page 51 of the writ.
Yeah.
That is typed in bold letter. Initial appointed to railway on.
You see, from the very beginning of that paragraph, what is the position? What the Union of India said that why you are not
That in
entitled.
reply to the averments made in para 4.1 and 4.2 of the original application, it is respectfully submitted that Sri Damodar Bindhani, ex-senior clerk ad hoc, initially appointed railway with effect on 6/9/79 as scholarship regular, and thereafter he had availed 2 ad hoc promotions, that is junior clerk, grade pay rupees 1900 and with effect on 6/5/1992, and senior clerk in grade pay rupees 2,800 with effect from 1997 and retired with effect from 31st July 2011 on attaining the age of superannuation and all the financial benefits paid to him in the rupees 2,800 manner. Then page 52. Again, as per para 1 of annexure to the aforesaid RB, financial operations on remission scheme are counted from the direct entry grade, full stop. Accordingly to the above RB, the applicant would have been granted grade pay rupees 1,900 and 2,000 and GP of 2,400 from his initial regular post of scholarship in GP of rupees 1,800. But he has already availed grade pay of rupees 2,800, which is higher than his eligibility on third MSc, that is grade pay of rupees 2,400. As such, applicant is not due for further MSc benefit.
Because you are not regularly.
So
30 years regular service.
My submission before my lord is that your lordship kindly give a glance.
Come to the impugn order para page 64. Para 9. The reasoning.
In the instance case, obviously and axiomatically, the applicant got ad hoc promotion in construction organization and enjoyed the benefit of higher scale of pay without making any objection. Rather, in para 4.8 of the OA, it is specifically stand that as per para 28B of the MSc scheme, an employee is entitled for third financial operation on completion of 30 years of regular service or 10 years in the second promotional post. It is also crystal clear from the MSc scheme that one is entitled to third financial operation on completion of 30 years of continuous regular service and, admittedly, the applicant was working in a post due to ad hoc promotions granted to him in construction organization and was not holding a substantive post. In view of the facts, provision of rules and law discussed above, we find no merit in this way to allow applicant third MSc in grade pay of rupees 4,200. Hence, the Western sans any merit is dismissed, leaving parties to bear
What
their.
is your submission?
My lord, I want to place.
This you did not dispute it, that
Your lordship
this
kindly
is
give a
the,
glance page.
MSCP scheme. It indicates that when a person would get that third financial
Again.
obligation, right? So whether the case of the Union of India, and that is also accepted by the London Tribunal, that you are not entitled because of the scheme. You are not entitled to get that third financial obligation. What is the wrong in it?
My lord, your lordship kindly give me page 31, my lord. My date of second promotion is 1/4/1997.
Just a minute, 30?
1, my lord. My second promotion is dated 1/4/1997. So as on 1/9/2008, I have completed 10 years in that particular post. So as per para 28B of MSc scheme, an employee is entitled for third financial obligation either on completion of 30 years service or 10 years in the second promotional post. Admittedly, in this case, the applicant has completed more than 10 years in the post of senior clerk. Now, my lord, the question is, my promotion was ad hoc. That issue was involved in a particular case. I own the matter, that said matter carried to this honorable court, subsequently honorable apex court, where the issue has been set at rest. I have enclosed that order. I want to place that order now. Annex 10, the order of this honorable court. Page 44, para number 3 and 4, I am to place.
Yes.
Lord Counsel, appearing for petitioners, submitted that the tribunal, while passing the impugn order, has not taken into consideration clause 9 and 28 of modified Assure Career Progression Scheme, which was issued by the Government of India, Minister of Railway on 10/6/2009. Recommendation of 6th Central Pay Commission. The officiating period of the applicant should not be counted for grant of MSP as directed by the tribunal. Considering the above and after going through the aforesaid clause, it appears that clause 9 of MSP scheme specifically refer to regular service, which commence from the date of joining of a post in direct entry on a regular basis and the service rendered on ad hoc/contract basis before regular appointment on pre-appointment training shall not be taken into reckoning. In this case, my lord, admittedly my service regularized as a class. My promotion was ad hoc, but I was a regular employee, my lord.
What happened in this?
In this case, this court was pleased to dismiss the writ petition filed by the railway. Given that the before it SLP also dismissed Annex 11, my lord, page 47.
But 45, please read 45. Why you left in between? Clarity comes. Therefore, the said clause is not applicable to the applicant. Clause 28 is the only illustrative how MHP will be granted. Better appreciation, so and so, so and so. And
the railway servant,
what is direct in that? Tribunal after taking into consideration.
Railway challenge.
Railway was before, my lord. Challenging the order passed by long term, allowing the original application.
No error. Take.
My lord,
SLP, this is.
Page 47, my lord.
as page 48, my lord, the Honorable Apex Court has paragraph number 2. Page 48, paragraph number 2. However, the question of law raised in the present petitions is open for being decided in an appropriate matter, my lord. So it has not. That will be decided. What is there? He is now challenging. It's a.
What is the question of law according to you?
The ad hoc promotion which he has taken
Will be counted or not?
counted on, but the scheme says it no. It is under Annex 2, my lord, paragraph 3. Annex 2, paragraph 3. That is the scheme says. Honorable Supreme Court said that that is to be decided on merit in appropriate case. Now he has challenged, so you file your counter affidavit. My lord. Then we'll decide what is there. My lord.
This case is appropriate case or counter?
This petition has been filed by the petition Damodar alias Damodar Vindhani, challenging the order dated 2/4/2025 passed by the Learning Central Administrative Tribunal Cuttack Bench Cuttack in way number 449 of 2018. It appears that the petitioner filed the aforesaid way with a clear feature as follows. Say you weighed on paragraph 8 relief sought for in view of the above fact to vote कर से जो A, B, C तीनटा अच्छी तेरा vote कर it appears that the after issuance of notice to the opposite parties, counter affidavit was filed in which the specific stand was taken as follows. Quote from paragraph number 4 and 5. The petitioner filed the rejoinder affidavit and The reply to rejoinder also was filed by the opposite parties. The London Tribunal, after taking into account the pleadings, so also the contentions raised by the Land Council for the respective parties, has been pleased to hold as follows. Quote paragraph number 9 of the impugned order, that is at page number 64 and 65. Mr. Rautray, Land Council, appearing for the petitioner, contended, referring to Annexure 6 series, that the petitioner got the second promotion as senior clerk bracketary ad hoc in constitution organization bracketary without any selection method. And he should have been granted the hard financial upgradation as he has completed he has completed 10 years in the second promotional post. And the rejection of his claim on the ground that the second promotional post was on ad hoc basis was not proper and justified. The Mr. Rautray submitted that in a similar matter, when relief was granted by the Central Administrative Tribunal, the matter was challenged before court by the Union of India, WPC number 22240 of 2017. And this court has been pleased to dismiss the writ petition by the order dated 14/3/2018. And against the said order, the Union of India approached the Honorable Supreme Court in SLP number so and so, that is at page number 46, which was also dismissed. However, an observation has been made that the question of law raised in the petition was kept open for being decided in an appropriate manner. The counsel, Mr. Patnaik, who is appearing in the Central Government Council,
Senior Panel Counsel.
Senior Panel Counsel, who is appearing for the Union of India, submits that rightly the London Tribunal has been pleased to hold that so far as 10-year completion in the second promotional post is concerned, that should be on the regular basis, and ad hoc promotion would not cover the case. And since the petitioner second promotional post was on ad hoc basis, therefore it has been rightly held that he is not entitled to third promotional upgradation. Stop. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land Council for the Mr. Patnaik accepts notice on behalf of all the opposite. All this extra copy of the writ petition resolved on Mr. Patnaik by within 3 days. Put up this matter 4 weeks time. The counter affidavit can be filed in the meantime.
No pleasure.
Item 3.
May I please, Mila? But I am attributing with the order of the Ombudsman at page, page Annex 4. of directing me to clear the dues of a wireless company, my lord, tower company.
Annexure 4 you are challenging.
Annexure 4 and also Annexure 2 is the order of GRF.
Now let us see your prayer first.
Being agreed with the order of GRF, Annexure 2, I moved the ombudsman. Ombudsman, my lord, relying the case of my lord.
Just a minute. Submit that he has instruction that in identical matters some orders have been passed by this court and therefore he may be. Yes,
My lords, to be fair, my lords, your lordship was of the, my lord, in fact, on the bench that your lordship have passed similar orders in light of the KC Kinnan judgment. My lords, I have checked up in the website as well as all these of internet websites. My lords, I failed to, my lords, find out in the identical, perhaps it has not been uploaded in those websites. I have also checked with other discoms councils who are appearing. That was not there. I did not find it. But KC Kinnan judgment is barely applicable.
The owner of the land is legally enjoined with the bound and duty to clear the area of electricity, and the owner of the land may recover the amount of area electricity used from his licensee on the recourse to law, which so advised that the owner of the land is legally due to contribute the dues in respect of the on-field area electrical dues as it is by the discount. And unless and until the payment clears the electrical dues, a illegally sustainable direction cannot be issued to the opposite party to provide power supply connection to the claimant of the petitioner. You asked the land council for the petitioner with regard to the ratio, the decisions once we seek some time to go through the same and apply this court on the next day. You are the owner.
Lord, I am the original owner, my lord.
So how do you overcome this decision?
My lord, this decision is not applicable so far this case is concerned. The key difference between my case and the Kinnan case is that is dealt in the matter of a transfer of property and the subsequent purchaser. The purchaser, if purchases a property, then the regulation says that he has to apply for a NOC to the licensee. If the NOC will not be issued within 30 days, my lord, then the licensee cannot claim the area. Here, my lord, I am the owner.
Yeah.
I have let out a piece of portion of my land to a wireless company, my lord. And whatever agreement he has made with the supplier, I have nothing to say. I have never furnished any affidavit, any undertaking that in case he will have some area, I am liable to pay, my lord. I am the owner. I am not the person in a possession or
Where is that agreement?
Agreement, my lord, they have suppressed that, my lord.
No. That agreement which you have made.
That is the agreement between the tower company and myself, my lord.
Where is that agreement?
My lord, I have filed, my lord, that copy, lords have a glance, my lord. That is, my lord, initially I have given a power supply from my connection, which I have obtained, my lord, my connection. And it was agreed that he will obtain fresh connection from the department and will pay the dues, my lord.
So,
My lord, what agreement he has done with the, he has executed with the licensee and obtained.
so your agreement with the person.
Your agreement with the.
Yes, my lord, my agreement is page 23, annexure, my lord. Page 23, that is, my lord, annexure. 22, 23, my lord.
Annexure 3 series.
Annexure 3 series, my lord. The lords may see, I have, this is, I
has
am
been
the
described there as licensee.
licensee.
You are the licensor.
Yes, my lord.
Right.
My lord,
So, you come
and
to
so
the-
far this license is TPCODL, my lord. The licensee under the Electricity Act, my lord.
No, see, referring to that, suppose you will apply very those clauses
My lord.
in the agreement.
You lords may see page, have turned to running page 26, please. The licensee,
Yeah, just a minute.
running page 26,
26, okay.
my lord. Clause IV. The licensee shall be entitled to fix a CMT,
Clause kete kouchandi?
sir, 4.
Oh.
The licensee shall be entitled to fix a quote on the scheduled property. The height of the tower shall be as per the technical requirement, but not exceeding the height of 60 meters, and to which no objection will be raised from licensor or anyone claiming under him for them.
Electricity ବିଷୟରେ ଆସନ୍ ସେଗୁଡା କାହିଁ ପଡୁଛି?
Then, my lord, the lords may see the rent is at clause 3 bottom, my lord. The consideration license paying the license fee here in ete. Then, my lord, in one place I have, my lord, lords may turn to page 28. 28. Para VII. The licensor shall provide ways, paths, stairs, and common passages to the licensee to have peaceful access to enter into the schedule mentioned property without any hindrance, and the licensor or anybody claiming under them shall not obstruct or disturb the ways, paths, and common passages. The licensor shall allow the licensee to erect sufficient number of electricity poles in the ways, paths, and common passages that lead to the scheduled property for the purpose of taking electricity power connection from the nearest transformer or electricity post erected by the electricity board without any obstruction or disturbance from the licensor or anybody claiming under them, my lord. And then, my lord, clause 10, lords have a clause X. The licensor shall provide this KVA electricity through a submeter, the charges for use of which shall be paid by the licensee as per the meter reading. In the event the licensee requires extra load, licensee shall be entitled to make the application to the electricity board, and the licensor shall extend all necessary cooperation and assistance.
That cooperation is the liability.
No, this is the first instance I provided a power supply by installing a submeter to the tower, and thereafter he obtained a direct connection from the department. Thereafter, what is my liability, my lord, to this, my lord?
No, where is that?
My lord, here is written, the licensee as per the meter reading. In the event licensee expires, licensee requires extra load, licensor shall be entitled to make application to the electricity board, and the licensor shall extend all necessary cooperation. My lord, for the purpose of construction of a tower, he has taken a
for obtaining the such load, and the cost of the same shall be borne by the licensee.
My lord, ସେଇଟା ସିଏ ମୋଠୁ ଗୋଟେ ନେଲେ କନଷ୍ଟ୍ରକ୍ସନ ପର୍ପୋଜରେ ଟାୱାର କନଷ୍ଟ୍ରକ୍ସନ ପର୍ପୋଜରେ ମୋର ସବମିଟର ବସେଇକି ନେଲେ। ତାପରେ ଯେତେବେଳେ ତାଙ୍କର ସେ ଟାୱାର ରନ୍ କଲେ, whatever condition he has entered, whatever agreement he has executed, that the licensee did not produce before the GRF. That is why, my lord, lords may turn to the GRF observation. GRF have though observed everything, my lord, but has committed the error of law, my lord.
Where is that?
Lords may see page 18. Page 18, order of the GRF, para 2, the OP has intimated to the forum in his submission that the complainant, Mr. Dhirendra Sahu, had executed a lease agreement on 14/4/2008 with the Messrs. Disnet Wares Limited to use his plot ete, khata number ete. Sir, page 18 of the GRF order. Paragraph 2. The OP has intimated to the forum in his submission that the complainant Dhirendra Sahu had executed one lease agreement on 14/4/2008 with Messrs. Disnet Wireless Limited to use his plot number 480, khata number 698 for tenure of 12 years for the purpose of erecting telecom tower and associated equipments for cellular mobile service. Considering the above lease agreement, as consent of the landowner, power supply was effected to Messrs. Disnet Wireless Limited CD 4 kilowatt at GPS category. It is admitted by both complainant and OP that power supply to the telecom operator has been long disconnected. My lord, they are required to maintain a record of a disconnection as per regulation 18, my lord. They have not produced that, and they are observed. And however, the date of disconnection of power supply could not be furnished by the OP. The OP should not be continued billing of a consumer after disconnection of power supply for more than 2 months. Here, my lord, I may be allowed to submit. My lord, suppose a power supply is disconnected for 2 months due to non-payment of due. Then it is the duty of the licensee to, for deemed termination of the agreement and the whatever security is there, ସେଟା ସେ ତାଙ୍କଠୁ ରିକଭର କରିକି ପ୍ଲସ୍ ମାଇନସ୍ କ'ଣ ତାଙ୍କୁ ଇଣ୍ଟିମେଟ୍ କରିବା କଥା। ସେଇଟା ସାର୍ ସେ କରିନାହାନ୍ତି। এটা 13 ରୁ ଡିସକନେକ୍ଟ ହେଲାଣି, କିନ୍ତୁ 21-22 ପର୍ଯ୍ୟନ୍ତ ବିଲ୍ ଗଡ଼ଉଛନ୍ତି, ଯୋଉଟା କି ସେ ଆମର ଯୋଉ ଲିଜ୍ ଆଗ୍ରିମେଣ୍ଟ ଥିଲା 12 ବର୍ଷ ସେଇଟାକୁ ଅବଜର୍ଭ କରିକି କହୁଛନ୍ତି ଯେ ସେଇ ପର୍ଯ୍ୟନ୍ତ ଏରିଆଟା ତମେ ଦିଅ। ଆଉ ଯଦି ସାର୍ ତାଙ୍କର ଲିଜ୍ ଦେଖାଯିବ ବିଲିଂ ଷ୍ଟେଟମେଣ୍ଟ ଆଇ ହାଭ୍ ଫାଇଲ୍ଡ, ସାର୍ ସେ 50,000 ରିଟର୍ନ ପାଇବ କିଏ ଆମର ଯୋଉ ଡିସନେଟ୍ ଟାୱାର ତାଙ୍କଠୁ। And most peculiarity of the case is, sir, I am the applicant before the GRF, and the case has been registered in the name of Disney Tower, as if Disney Tower is the complainant before the JRF, and subsequently when I approached the Ombudsman has also committed the same wrong by registering the case in the name of Disney Wireless Limited. My lords may see, my application is, my lord, to the JRF is Annexure 1. I am Mr. the landowner. I applied that they are not giving me supply to my land. My lord, the case has been registered in the name of Disney Wireless Limited, my lord, as if he is the complainant. My lord, whereabout they got this and they registered this, my lord. And ultimately, my lord, the JRF, my lord, as held, my lords may see.
So, so far as the agreement which has been executed between you and that
मोर 4 किलोवाट पे मु ता कंस्ट्रक्शन पर्पस देखिली तापर से नेछन 12 13 किलोवाट कोन नेछन सर एटी अछि केते किलोवाट नेछन से ताकटू सेटा से सप्रेस करछन देलेनी थिस्ते जदि सर रिमांड कर देबे से प्रॉपर ईयर आउथरे से ताकू एग्रीमेंट प्रोड्यूस करबे व्हाट माने सर हमें गोट सप्लाई नेला हमें गोट एग्रीमेंट एग्जीक्यूट करतो लाइसेंस सहित पावर सप्लाई एग्रीमेंट सेतरे टर्म्स कंडीशन कोन अछि
what were the condition suppose that Disnet Wireless Limited
yes
applied for the electricity connection and you gave the electricity connection to him. So whatever dues was there, he was supposed to pay. Suppose some dues remain unpaid. Is there anything that the landowner on which this tower is, he has to pay? Is there anything?
Yeah, so I'll just answer your lordship's question.
सर मु 5टा घर भड़ा देछि टेनेंट माने सप्लाई नेचन डिपार्टमेंट को सर जदि से माने छाडी देले किछि रहिला बेकु सर ओनर विल बी हेल्ड लायबल इन दैट केस लॉर्ड्स मे टेक इट इन दिस वे आल्सो सिमिलर द केस हियर मु भड़ा देली रेंट एग्रीमेंट एग्जीक्यूट कर
No, that
से माने सप्लाई नेले पावर सप्लाई एग्रीमेंट एग्जीक्यूट कर
No. So because if it depends upon the nature of agreement.
यस मिलर
Suppose it is also your duty when you have given those persons on rent.
मिल फॉर दैट
You-
पर्पस दे आर
you-
ऑब्टेनिंग
you-
एफिडेविट एंड
You have
अंडरटेकिंग
to see that they are paying the rent regularly.
यस
So using the house for some time and on one day they will vanish and the electricity department why they
फॉर
will
दैट पर्पस
Come,
द लाइसेंस इज कीपिंग सिक्योरिटी
can you
मिलर
please come to page 29?
फॉर दैट पर्पस
Please come to page 29.
29
29.
मिलर फॉर दैट पर्पस लाइसेंस इज कीपिंग सिक्योरिटी मिलर
Please come to.
मिलर
What will be the effect of this clause?
Miller.
XII, read it.
29 मिलर
Yes.
हाँ the licensor agrees to pay the
You are the licensor?
मतलब in between so far a landlord and
I know, you read it.
हाँ licensor to pay the corporation tax
Corporation tax, municipal tax.
municipal tax
ground tax,
sir it is
property
my
tax.
land I am the owner of the land I am
Can
to
you
pay.
please read it?
Property tax water tax and all other taxes charges and levies as imposed by various authorities
Authority.
for the scheduled property
For the scheduled property.
scheduled property
This is one of the charges. Next, read it.
Miller
The licensee
shall in
That is
no way be affected by any demand notice and the licensor shall indemnify and keep indemnified the licensee in case of any action, claim or damages from the municipal or any other
Just a minute,
against the
just-
licensor. Something different, Miller. It is not. It will not apply to the electricity department, Miller.
Wait.
तो indemnify को दो. That was the agreement. This is authority, any authority.
No, it is your divorce.
The
It is
taxes,
my lease agreement,
charges,
Miller.
taxes, charges levied as imposed on various authority.
Miller, why they will suppress their agreement, power supply agreement?
Different thing. You
Miller, it
you are
it
aware.
only relates to my property, Miller. Since I am the landowner, property जहाँ tax, municipal tax हो, जो कौन tax हो,
And
I am liable to
it
pay.
includes any authority.
It
any
will not
imposition.
include everything. Miller, electricity department charge at इधर केम जासी हो सर?
Why did not you produce that agreement which
Power supply
that
agreement.
has been executed between you and that man, that discount?
Disney.
And if I have given any
suppose-
undertaking, Miller, that
One
should be-
minute.
Just a minute. Suppose there would have been any clause that in case the Disnet wireless limited, some electricity dues are remain unpaid, then he vanishes, let us say, then the owner will also be held liable. So if that clause is not there, then how the owner's responsibility would be there? It is an agreement between you and Mr. X. It is
There is
correct
no
that
privy, there is no contract between us.
X has utilized the land of this petitioner for installing that
Tower.
tower.
And for that, he might have given you the security also. You might have forfeited that security.
May I answer your lordship's
Sir,
query?
ସେଥିପାଇଁ ହଉଛି regulation 16. May I place the regulation 16 for a moment, my lord?
1 minute, let him explain.
Let him-
Let's-
For the moment, the lordship may kindly appreciate. If power supply to any consumer remains disconnected for a period of 2 months for non-payment of charges and dues and for non-compliance of the direction issued under this code, and no effective steps are taken by the consumer for removing the cause of disconnection and for restoration of power supply, the agreement of the licensee with the consumer of power shall be deemed to have been terminated on the expiry of the said period of 2 months without notice, provided the initial period of agreement is over. Sir, power supply तांकर sir disconnect ହେଇଛି 9/2016. Lordship, see page 45 of the billing statement I have filed. Sir, last reading थिला 43,957. तापर आउ कंजप्शन नाही सेठी 2 मास पर से सेठी बिल स्टॉप करके सिक्योरिटी एडजस्ट करके दे देबा कथा किंतु सर वॉलंटरली दी कंपनी जेहेतु तांगा टावर डिफंक्ट हला पर थिला काले से माने रिवाइव करिवे से तार 3-4 मास जो लोड फैक्टर बिल रेज करछिन पेमेंट करछि तांगा सिक्योरिटी भी अछि किंतु अमर सिमान कहले हमर जो पावर सप्लाई एग्रीमेंट कला 12 वर्ष थला हमर से मो लैंड फंड दलानी मु चिठी लेखिले सेटु तापर ये सेटा को देखिकरी कहले तमर सेही डेट परंत तार एरिया रहउछि एतिक
Yes, sir. What is your reply?
टोटली से
Just-
50,000 टका
Please,
सर तार
okay, here.
Let's, there are two aspects to it. The first question which your lordships put forth, whether there is any law in the Electricity Act or the code
Yeah.
that if the tenant, for whatever reason with the landlord, vanishes from the property, whether the electricity discom can recover the same from the owner who is the landlord. That is the first question. The second question is with regard to revision of bill, that when it should have been calculated. These are the two questions involved. So far as the first question is concerned, this was a question which has been raised before this honorable court as well as the honorable Supreme Court time and again. The latest judgment governing this question is the K.C. Kinnan judgment. That judgment says, if the electricity code of the concerned state has a law stipulated in that code, state code, that the discom can recover, then they can recover. If the state code does not have any provision that if the tenant vanishes, it's the owner who should pay back to the discom, then the state discom cannot. Your lordship may kindly see section 50 of the Electricity Act. If your lordship is holding the OLR book, then page 37.
It should be over.
837.
Page 37.
Huh?
Page 37. If your lordship is holding this book,
Section 50.
section 50, page 37.
Section 50.
Section 50, if your lordship says. That is the genesis of this provision. Your lordship will see the footnote at section 50 that was inserted in 2007 amendment. Your lordship sees to the bottom of the page, 37.
15/6/2007.
15/6/2007. Now, if I may place section 50, my lords, because all these things are relevant for K.C. Kinnan judgment. The Electricity Supply Code, the State Commission, which is the OERC in our state, the State Commission shall specify an electricity supply code to provide for recovery of electricity charges, intervals of billing of electricity charges, disconnection of supply for non-payment thereof, restoration of supply of electricity, measures for preventing tampering, distress or damage to the electrical plant or electrical line or meter, entry of distribution licensee or any person acting on his behalf for disconnecting supply and removing the meter, entry for replacing, altering or maintaining electricity lines or electrical plant or meter and such other matters. I'm relying on the first sentence, which says
the state commission shall specify in it electricity code to provide recovery of electricity charges. By virtue of this provision, the OERC or different regulatory authority in different states formulates a code. Earlier, the first code was 2004 code. It was amended in 2019. Now, your lordship may see the book, that particular book, if your lordship may come to, well, it's page number 540.
What is that?
That is the code of that OLR book.
What is the name of the code?
That would be Odisha Electricity Regulatory Commission Distribution (bracket) Conditions of Supply Code 2019. In short, OERC Condition Supply Code 2019.
Page 540 of co clause
540, if your lordship sees the first page, it says the code. Name of the code. Now your lordship may see, in exercise of powers conferred by section 50, which I just read out to your lordship, they have formulated this code. Now this code is the entire thing in the state, in our state, which governs the distribution supply of electricity.
Come to the relevant provision.
Malots may kindly see regulation 17.
17.
17.
One seven.
17 will have 6 clauses.
Yes.
The learned GRF has relied upon clause number 1, 17.1 and 17.6.
The number, it is mentioned as C number 17.
Clause, that would be clause.
Clause. Clause number 17. Who clause?
17 raw I and 17 raw VI.
Achha.
These are the, yes.
Clause number.
No. I
17. Roman 1 out of Roman
6.
BI. That is 552, 550. A Mogila Boita Mogija. A boy would have Saburo double set nor.
Now let's, I'll place 17I. It starts with, if the applicant in respect of an earlier agreement executed in his or her name or in the name of his spouse, son, daughter, parents, or in the name of a firm or company with which she was associated either as partner, director, managing director, is in arrears of electricity dues or other dues for the same premises or his or her other premises situated in the same DISCOM or any other DISCOM in the state, the application for supply shall not be allowed by the engineer until the arrears are settled in and paid in full. That is clause number 1. Clause number 6, if your lordship says. It starts with any charge of electricity. Any charge of electricity or any sum other than charge for electricity as due and payable to licensee supplier which remains unpaid by a deceased consumer or the erstwhile owner or occupier of any land or premises, as the case may be, shall be a charge on the premises transmitted to the legal representative or successor-in-law or transferred to the new owner or occupier having lawful occupation of the premises, as the case may be, and the same shall be recoverable by the licensee as due from such legal representative or successor-in-law or new owner or occupier having lawful occupation of the premises, as the case may be. Now, your lordship, after reading section 15 and 17,
it says that new owner or successor.
Successor.
Not the original owner. That's what his case.
Not at all applicable. Those clauses not applicable to me.
My lords, if your lordship now sees, these are the 2 clauses which has been relied upon by the GRF and ombudsman. Therefore,
This is not applicable. How can you? This is he's not the new owner. He's the original owner.
Yes.
And occupier has gone.
Sir, transfer jodi heithibo TP Act anusare tahale owner
So
occupier.
that is how this he says that that decision is not applicable.
My lords, if your lordship now sees again 6, the occupier having lawful occupation of the premises as the case may be, he is currently the owner of the property.
It is transferred to the new owner or occupier?
Occupier.
He is not that means
Occupier
by
means
virtue of, he is the original owner. How are you bringing him within the,
Correct.
occupier was that man who had vanished,
Well, it's
that company.
well, it's the company against in which the particular petitioner has entered into a lease deed. If he vanishes,
Yeah.
and the lease deed stipulates within themselves who is to pay the charges, electricity
So
charge.
it's the reason he has paid security
Yes.
and taken the connection.
Yes.
Within 2 months, if it was disconnected, you should have collected and adjusted the security. You didn't do it.
Security
Why
with
should
the license.
the original owner would be responsible for that?
It's
What is the privy you have with him?
Malas, the privy is the only on the premises, not on the owner.
All right, we are issuing notice.
Miller,
All right, done.
other aspect I mean,
That's issue notice.
for the moment,
One,
sir, se jo kale due achi, sir, ye jo deiche mo due gote tonga nahi tanga already
All right, all right.
That's a different
This
story.
petition has been
ଯଦି
filed.
due thibo se nahi question uthibo.
Now we are studying the legal issue.
absolutely.
The writ petition has been filed by the petitioner Dhirendra Nath Sahu, challenging the order dated 22/2/2024, passed in case number 6 of 2024 by the Grievance Redressal Forum Qatar under Annexure 2, and the order dated 13/1/2025, passed by the Ombudsman 1 in CR number OM 121 of 2024 under Annexure 4. The Land Council for the petitioner submitted that to the Ombudsman in the order dated 13/1/2025 has placed reliance on the decision of the Honorable Supreme Court in the case of K.C. Ninan versus Kerala State Electricity Board and others reported in 2314 Supreme Court cases 431. But the said decision has no application to the factual scenario of this case. The Land Council appearing for the opposite party, opposite party, you are appearing for the opposite party's number
Malas, I'll be appealing
1 and
for
2 na?
OP number only 1. Malas.
Acha, opposite party number 1. Why are you making this ombudsman and
Formal party for appreciation for the
Acha,
purpose of appreciation. I have
opposite party number 1 place the
Section 50
section 50
of electricity.
of section 50 the whole C
Electricity.
Electricity
Act
Act
2002.
2003 page number kete koile?
That's 37. 37.
37. That's which deals with the electricity supply board and empowers the state commission to specify
Regulations.
and electricity
Modify the recovery.
codify the recovery procedure of the electricity charges. And he further placed the Odisha Electricity Regulatory Commission distribution bracket condition of supply for 2019, which was formulated in exercise of the powers conferred by section 50 of the Electricity Act 2003. The Land Council for the opposite party number 1 placed clause number 17(1) and 17(6) of the said code which reads as follows. 17(1) टा अछि पेज नंबर 552 और 17(6) टा अछि 553 पूराटा कोट कर दे. The Land Council for the petitioner submits that the aforesaid two clauses are not applicable in the case in hand, and the opposite party number 1 deliberately has not produced the
Power supply agreement.
the agreement,
Power supply
the
agreement.
power supply agreement which was executed between the opposite party number
Yes, sir.
1 and
that
what is that? Discount.
consumer. Disnet Wireless Limited.
Disney.
Disnet where consumer consumer, that is Messrs Disnet Wireless Limited, right?
With the then Sessu.
Huh?
With the then Sessu.
With the then Sessu. Stop. The Land Council submits that in view of the provisions, you talk about the mass with the report.
Clause 16 and my submission is Milord. This 19 code is applicable effective from 11
16 कोण
16 of OERC distribution condition of supply code 2004. Clause 16.
आपण पर बही पासन करो
Sir.
ए बही नाही सेटा
ନାଇଁ ସାର୍ ସେଇଟା ଆସିଲା 2019 ରୁ ଆସିଛି ସେଇଟା ଆପ୍ଲିକେବଲ ନୁହେଁ ଟୋଟାଲି କାହିଁକି ନା 13 ରେ ଯଦି ପାୱାର ଡିସ୍କନେକ୍ଟ ହେଇଛି ଲାଷ୍ଟ କନଜମ୍ପସନ ଏ 19 କୋड ଟୋଟାଲ ଆପ୍ଲିକେବଲ ନୁହଁ.
अच्छा, he further submit that this 2009 code is not at all applicable case in hand, since the power disconnection, supply disconnection was made in the year 2013, na?
Milord codes applicable.
2013.
Milord
You said that is September 2016.
2016. September 2016.
He submits that in the case in hand, the
2004 code is applicable.
just it are four naata kon eta
OERC distribution conditions of supply code 2004.
acha, in the case in hand, Orissa Electricity Regulatory Commission Distribution bracket lekontu conditions of supply bracket ends code 2004 is applicable, and it states in clause number 16 regarding termination of agreement, which reads as follows. Purata quote kar dega. It further, the Land and Council for the petitioner further submits that if the said Discom Wireless Limited did not pay the electricity dues, the opposite party number 1 should have terminated the agreement
Within 2 months.
within 2 months
After the disconnection.
By
Subsequent to
by
disconnection.
adjusting the
And to
security.
adjust the security deposit.
by adjusting the security deposit, which has not been done in the case in hand. Stop.
ସେ ରେଗୁଲେସନ 10 ଟା ଖାଲି ଥିଲା ଯୋଉଟା କି ଏଥିରେ 17 ହେଇଛି ବହୁତ ଗୁଡାଏ ପସିଛି କିନ୍ତୁ ରେଗୁଲେସନ କେବଳ ଥିଲା ପ୍ୟାରେଣ୍ଟ ବାପା ନାଁରେ ଯଦି ଥିବ ଫାର୍ମ ନାଁରେ ତାହେଲେ ରେଗୁଲେସନ 10.
Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. এটা থেকে ফ্ল্যাগ নাম্বার দেবে যে ক্লজ 16 টা যে টিপিবে এই পুরোনা বইবে
Flag কে মারি দিয়ে দেবে।
এটাকে ধরো স্যার এটাকে ধরো পে বহি বি ধরো যে পেজ ডফালা লিখে দেবো হ্যাঁ issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. No notice is issued to opposite parties number 2 and 3. An extra copy of the writ petition be served on the Land Council for the opposite party. You have already entered appearance.
Yes, already in process.
Acha, name is there.
3%.
Acha, Mr. Maharana. Since Mr. Maharana has already entered appearance for opposite party number 1, extra copy of the writ petition be served on him. Put up this matter, 4 saptah par lage jantu. Counter affidavit, if any, be filed in the meantime, serving a copy on the Land Council for the petitioner. Any interim order was passed earlier?
A supply may be given, will abide by the final result of the case.
No. What is the IA you have filed?
Milord, I have prayed for supply of an electric connection.
That will be the final outcome. Can't be.
No, it will abide by the result. Any supply given to my premises will abide by the
That
final.
is tantamounting to allowing the writ petition.
Miller?
Tantamounting to allowing the writ petition.
Yes, Miller.
Why
Otherwise,
not?
ମୁଁ ତ ଦେବି ପଇସା
Let it
ଦଉଥିବି
be.
sir.
Let it be.
Connection.
1181 is since long it has been done. So yes, 4 weeks after. File the counter affidavit.
My lord, shall file it.
Sir, Lordship,
Interim application में भी issue notice कर दिया तो accept.
sir, I may be given a connection in the interim, which will abide by the result.
No,
Supply
that is-
of any
that
connection
would
shall be
allow.
abide by the
My
result.
brother is right, that would be allowing.
That will be allowed.
Yes, next.
No
Yes.
problem.
Item 4.
Sir, I am with.
Item number 4,
Item 4, your lord, without, I am the landlord. There is single page line. My tenant has got a power connection to that without my consent, and so the agreement with him has been cancelled.
how without the consent it can be taken, because there must be some kind of, in that form, it must be necessary that the.
That is what I am claiming. That is what I am saying, my lord. I went to GRF. He went to GRF. GRF says that give me a connection. I questioned that before the appropriate authority. They said that it is a civil dispute. That is why I am before Lordship. I am serving a copy on Mr. Maharana. Your Lordship may call it this Friday.
No,
or-
ordinarily, suppose somebody takes a rent.
Yes.
So used to the owner gives the line connection to, by placing the individual meter, he used to collect it. But suppose on his own, the tenant
Tenant.
applies directly before so and so. So before supplying the electricity, the consent of the
Yes, that is
owner-
what is required. It's fundamental. Without that, they have given the connection.
This is eviction petition in disguise.
My lord,
This is eviction petition in disguise.
my agreement with him is, my lord, that is cancelled now.
Not required.
Your tenant is not.
In fact, Malats, there are
No consent of the owner is required.
There are Malats divergent views on the NOC by the Honorable Supreme Court. There are divergent views. In one of the matters, the Honorable Supreme Court has clarified that since it's a basic utility services, as long as the person is inside the premises, rightly or wrongly, the distribution companies for electricity, water, or other services cannot deprive him for basic
Section
necessity.
45 and all.
It is not basic. Giving a
Basic
giving line is always there.
The second line of judgments are of the line that if the tenancy has terminated,
Yes.
then if the owner comes to the DISCOM and says that I do not want him or I do not want electricity connection in that particular premises or in that particular name, then we have to issue them a show cause notice, whosoever is in the premises, that the owner has complained. 15 days time is given under section 56. You sort out the dispute with the owner, or we will be bound by the owner's saying, then we have to disconnect. These are the two line of judgments of the Honorable Supreme Court. Because if the dispute between the owner and the tenant remains, and sometimes what happens, Malas, they are going to the civil court obtaining a status quo order, or they are obtaining a no coercive action order, we have to abide by that. So facts are to be seen, Malas. But the code, as your lordship says, the code specifies that if a new connection is to be given,
Yes, is right.
then the form itself says,
That
if-
is it.
Yes, yes.
yeah, the form itself says you have to take NOC as per the code from the owner.
Consent of the owner.
And if in the case of government land, where the where encroachers are there in the government land, also the code specifies that you have to take an NOC from the local authorities, let's say the municipalities or the tahsildar. Then the code also says another power is given because of lot of timing issues. Somebody may go to the tahsildar and it may take some time. The executive engineer has the power to dispense with the NOC for the time being, and subject to condition that he may produce it subsequently. All these are there in the code. But one line of the 2023 Honorable Supreme Court says that basic human rights, and it cannot. Once he has entered into, there is already a connection, then that issue
Existing
comes.
connection cannot be removed.
But the new connection, we have to be careful.
Because if ultimately you are likely to suppose some dues remain unpaid,
My lords.
as in this case, the previous,
Item number 3.
and you are intending to recover it from the owner also.
My lords.
So the owner's consent is very vital
Very
in that case.
And my lords, the difficulty is in item number 3, my lords, as it has been already over, the KC Kenan judgment's concept has fallen. Any dues whatsoever, if is not recovered, ultimately it will come to all of us.
That's
In
right.
some way
That's
or
the
the other.
idea.
And some way or the other, somebody has to pay it.
That will interpret.
So the tariff will grow. The general public will suffer. Because distribution, we are doing it, a lot of infrastructure has to be developed. So if nobody pays, then all of us will pay.
But in this present case, I think he is the subsequent purchaser. You are the subsequent purchaser.
No, I am the original owner. The tenant is there. The line was, single phase line was already there. Now there is something, my lord, beyond that, because they want to usurp the property and all that.
Perhaps there has been a civil dispute, as my lord.
You give a copy. Lord.
I am giving a copy.
Pardon me, Lord. In Kesinan's case, my Lord, while deciding 19 number of cases, my Lord, the Honorable Supreme Court has framed the issues, 4 number of issues. What are those issues? Those are mentioned D, E, F, G, my Lord. All speaks about to transfer when new title is created by virtue of a transfer under the TP Act.
Yes, that is what it is.
And in case of auction purchaser also, you know, all those that the issues covered under the 19 cases.
In fact, one of the issues was very vital, whether a power to recover arrears of a previous owner or occupier
That means
from an auction purchaser or subsequent can be recovered by the discount. That is where the state code comes into
Yes.
vital picture.
in absence of any transfer.
Mr. Sadangi Land Senior Advocate submits that he will serve a copy of the writ petition on Mr. Maharana, the Land Council, appearing for the opposite party number 1. During course of the day, you supplied it to the
Yes, in course of the day.
put up this matter.
Right.
On next week, Aniva,
My lord.
put up this matter on 22nd of October 2025. Yes.
No, sir. I'll be appearing for OP 1 and 2.
Okay, opposite submit that he has instruction to appear for opposite party number 1 and he will appear in. Let it respond, but he has instruction and the copy is to be submitted. Yeah, obliged.
Item 5.
So that in this case, the petitioner was working as a postmaster, and on 9/12/2018,
Which order you are challenging?
this is under Annexure 1, passed by the London Central Administrative Tribunal.
9/8/2024.
Yes, starts from page 16,
Where is the original application?
and that is at Annexure 2.
Who? So what was the prayer made by the opposite party?
That also.
Relief sought for.
Yes, page 27. Starts from page 27.
No, it is in page number 40. Running page 40, 41. And after hearing the land council so and so, to pass the revised select list.
Yes.
And at annexure A/5 in respect of the selection against the
Vacancies of Sundargarh division for the year 2018, and direct the departmental respondents give promotion to the applicant to the cadre of PA/SA from the date of promotion of his juniors by issuing a fresh selection list. My lord, if your lordship will allow me, my lord, I will say the fact and details, my lord, in short.
No, where is your counter affidavit?
Well, that is at
Annexure
page
6.
95, Annexure 6.
So what was the objection raised in which paragraph?
My lord.
Paragraph of your counter affidavit. You have indicated your main objection to the relief sought for. That this man is not entitled to get that relief because of these reasons. What are those paragraphs? uh, page 100. Page 100, madam. Page 100, yes. Since second para, since qualifying marks for paper 1, LGP oblique LGS reduced to 38 from 38.4. One Sri Satyanarayan Mahanta, postman, Raurkela headquarters, under Sundargarh division, candidate of the aforesaid examination, has passed the examination by securing total 100 marks. Page 138, paper 2, 62. Who was earlier declared as fail for securing 38 marks in paper 1 against required qualifying marks of 38.4. That 38.4 was rounded up. And it is.
If the rule says 40%, how can you round it up?
No, my lord, why this? Rule says 40%. This rule is still intact, my lord. It is not disturbed. The rule is there. Rule is 40. We are also admitting that 40%. But my lord, total mark was 100.
Your total mark was 100. Two questions were wrong. So therefore it came to 96. 96, 40% is 38.4. You rounded it up to 38.
Yes,
that is the case. Can you do it under the, if the rule says 40%, 40% is 40%.
My lord, fractions and decimals are not possible, my lord. This cannot be done. So this is how, my lord, government framed a guideline in this respect. This guideline is at page 111. As per this guideline, this was rounded up because fractions and decimals answers are not possible. This is how.
There are two things which is coming in your way. Against the rule, you have done it. Second is, once the examination is started, in between you can't change the rule.
My lord, examination started, it is applicable to all. Not that a person is going to be prejudiced by these things. Yes. Paragraph 8. Yes.
Take the page number 25.
Well, that is mentioned there. I do admit that is not being. Yes. Well, what happened? Today this list is prepared. Selects. It is declared that so-and-so persons are selected. But just 2 days after, it is found that some questions are ambiguous, and these do not confer any answers also. So, for like judgment in them, it was applicable to all, and these 2 questions are deleted.
That further exposes your efficiency not acting in general.
No, this is applicable to all. That doesn't mean that one person is going to be prejudiced. Out of these 90 marks, people candidate must secure 40%. So if this 40% was applicable to all.
It's all, but it comes 38.4.
38.4.
So how did you, person was not at 8, you say that 2 questions were wrong. So everybody was given that benefit. It's all right. But if 40% comes to 38.4, then the persons who have secured at least 38.4 could have given, but this man has
Two of them.
They got 38%, not 38.4.
Then, your lordship is correct to this extent. But subsequently, a revised guideline was issued by the Ministry of Postal Department. Yes. My lord, as per the rules of postal GTA rules, my lord, there is a rule. This rule has been formulated, and as per this rule, my lord, this guideline has been framed. On last occasion, when I was discussing with these officials, my lord, they have said that a rule is there. Sir, total mark re more 100 रहुची जे unqualified तारा 92 किंतु 8 रे तारा 38.4 ताक रहुची 42 but I got selected in view of higher mark in aggregate. That is correct. So rule जो अच्छी they have said that this rule will be provided to me just next week. There is a rule of their own guideline.
There is a rule to amend the rule.
No, not at all, not at all. My lord, if my lord, this, the marks are in decimals and fractions that can be rounded up. Their own rule is available.
Before the process started, once process started, people participated, they obtained the marks. Thereafter, you can't,
My lord,
You see, 0.1% is much important.
no, much.
And even if 0.4%, somebody is not having that, you are reducing it and giving the very big person.
My lord, may kindly, for a moment, my lord, page 92, your lord's may kindness. This will suffice my case. And this has been framed as per the rule, not beyond rule. Page 92. 92. Running page 30 to page 90. My lord, reference just thereafter, one sentence thereafter. I am directed to intimate that the directorate, by its letter number so and so, dated 22/2/2019, has issued the minimum qualifying marks for the evaluation in both the papers of the aforesaid examination as under. The detail, it is mentioned how much mark is to be secured. 36, 94, 94, paper 2. It is unreserved candidate may run 38%, 38%. Yes, yes. That has been changed in view of the guidelines. My lord? No, my lord, there is a guideline. This is at page 111, Annex 7. This letter has been issued by the Government of India, Ministry of Communication, Department of Post, to all the Chief Postmaster General. It is applicable in rem, not in persona. Limited departmental competitive examination conducted on dated so and so for promotion of postman. So and so, so and so.
One of them got selected.
Yes, right now he is performing opposite part number 2.
Satyanarayan.
He selected, he has also scored highest mark than opposite party in aggregate. But in this particular subject, he is secured 38 and rounding up is made to 38, 38.4. But I secured higher mark than opposite party. Sorry, the perform opposite party. I will support. I will support. Understand this. No, he is a qualified candidate. So let him come and he's also let him file counter. I will also produce this rule, my lord.
The law is against you. What case?
Se rule tak sir mu dekhebi. Sir କହିଛନ୍ତି I have discussed.
Any rule? Do you have any rule that existing rule can be amended after the examination started?
No, so far as rounding up is concerned, rounding up mark.
There is no doubt about it. Once the process started, people participated, marks only, there you can't change. That's what the tribunal also says. That's the problem. Otherwise you have right. Nobody can stop.
Lawrence Tribunal has not entered to that arena. He has hold that since this rounding up is not permissible.
Likely not. More a problem.
Next to go, I'll give more clarity.
This application has been filed. The Union of India support. Challenging the already line you already passed by the transfer plan is challenging. Perfect case letter. Technology doesn't think of there appears that opposition party don't want
Party number 1, CORAM song, filed original application. Yes. Was revised to select this. In respect to the selection, vacancies of Sundargarh division for the years 2018. And carried the petitioner to give promotion to the cadre of new efficacy of the period of promotion of the years by issuing press decisions. The factual scenario would reveal paragraph number 5 ଅଛି ହେଲା after issuance of notice, the petitioners appeared before the Land Central Administrative Tribunal and filed the counter affidavit, wherein the main stand has been taken that a paragraph, page number 100, the qualifying marks, since the qualifying marks for paper 1, bracket to LGP oblique LGS was reduced to 38 from 38.4, comma, the
by applying rounded up
the
principle.
Opposite pro forma opposite party number 1 postman Raukela head office under Sundargarh division, candidate of the examination passed the examination by securing total 100 marks, that is paper 1 38 and paper 2 62, who was earlier declared as failed for securing 38 marks in paper 1 against the required qualifying marks of 38.4. And further stand has been taken that since the pro forma opposite party number 1 secured more marks, that is 100, than the opposite party number 1, which secured 94 marks, comma, the pro forma opposite party was selected for appointment as PA under UR category in Sundargarh division by replacing the opposite party number 1. The Land Tribunal, after considering the pleadings and hearing the Land Council for both the parties, has been pleased to hold and placing reliance in the decision of interdiction refer to para 6 रे से उड़ा पूरा दिया है ना has been pleased to hold as follows according to paragraph number 8 and 9. The Land Council for the petitioner referred to the सेटा जोटा आपण देखुथले जो चेंज कला सेटा होती कोटर
Page 111.
अच्छा
Revised guideline.
हाँ right. Placed the later it is revised guideline you dated 22 February
2019.
ନାମ ଆପଣ ଯୋଉ 38 ଯୋଉଟା କହିଲେ ନା 38% କରେଇଗଲେ କଲେ ବୋଲି ସେଟା କୋଉଟା annexure 7 please see to it. Annexure 7 को आसंदी
5, annexure 5. He was pointing out 5.
annexure 5 referring to the annexure 5 which is the declaration of result dated 25 to 2019 submits that since two questions data question कौन थिला?
Two questions are ambiguous and even not contains any answer.
Were ambiguous out of 100. So those two questions were excluded,
Deleted.
deleted, and out of 96, though the qualification mark was 40%, so and which comes to 38.4.
38.4.
But subsequently the revised guideline was issued.
Yes.
By rounding up.
By rounding up, it was made to 38%. That is annexure
Sir, 7.
7. The relevant letter dated 22nd February 2019 reads as follows, on the basis of which this result was declared, that is 22 to 2019. Taro, upon paragraph number 7 टा होची relevant para 7. Not good काम करंती. Or पुराटा टिपी जनता दे अच्छी. You come to paragraph 2, 3, 4, that would be clear. 5, 6 and 7. And also the explanation. We find that by introducing the guideline, revised guideline, the
This is a revised selection list.
The procedure for selection has been changed. If the petitioners would have struck to the initial, what is that, initial notification, then admittedly the pro forma opposite party would not have qualified for getting the promotion, as he secured 38%. 38%. It requires that 38.4 is the minimum qualification mark for selection if those two left out questions are excluded. After perusal of the analysis made by the Central Administrative Tribunal, relying upon the decision of the Honorable Supreme Court, we find that when in the original notification, there was no such relaxation provided by bringing the subsequent guideline dated 22nd February 2019. The pro forma opposite parties case should not have been favorably considered. Accordingly, we find that the learning tribunal has rightly quashed the revised select list for the year 2018 of Sundargarh division in respect of the selection of the pro forma opposite party, and rightly remitted the matter back to the competent authority to reconsider strictly in accordance with the discussions made in the impugned order. Accordingly, there will be found no merit in the writ petition, which is dismissed. Yes, next.
Item 6.
May I please, Your Lordship? I am through BC from the side of the petitioner, Lordship, and the copy already served, Lordship, to the Union of India.
Yes, you can argue. The counsel is here.
Lordship, in this case, I have challenged the order Annexure 7 that is passed by the CAT Central Administrative Tribunal Cutoff on the dismiss on admission stage, Lordship, on the ground of
Annexure 7.
Annexure 7, page number 42.
Yes.
On the ground that as there is no record is produced that the said order of removal was no longer in force and admittedly the husband of the applicant was removed from the service, we see no ground to admit this OA filed by the applicant praying for grant of pension and family pension. Lordship, as the rule said that if there is a removal of service, there is no chance to get family pension. But in this instant case, the husband of the petitioner suffered long-term chronic disease. Lordship, I have filed Annexure 1 with the Annexure 2 with the series of medical report and died in continuous of treatment as disease of kidney failure, Lordship. And petitioner's husband, petitioner Rajani Chawla, death certificate is Annexure 1. Petitioner Rajani Chawla, after death of the husband on 26/5/2017, Annexure 1, she moved representation, and Annexure 5 is the reply by the opposite party on Annexure 5, page 37, along with the personal notice, Lordship. As they served the personal notice and with giving 45 days of appeal, and the petitioner husband unauthorizedly absent without giving prior intimation to the authority. That's why he removed from the service. And as petitioner do not know about the proceeding, Lordship, and she already spent much more money as well as time for the treatment of her husband, Lordship, and she do not know the procedure. That's why after death of the husband, she moved the representation and also sought pleader
No,
pleader
these
notice,
are
Lordship.
all,
Annexure 2, Lordship.
madam, what you are submitting, those are all sympathetical thing, but the husband of the petitioner was removed from the service on dated 23/2008.
Where is that order? Do you have that order with you?
And that order was not challenged.
It's not also available order.
If that order was not
If that order was not challenged and that has attended the finality and your husband expired on 26/5/2017, And at that point of time, obviously, he has not acquired that he is not entitled to get pension.
Lordship,
Because how do you claim now?
Lordship, petitioner's husband already served 24 years of service. Although he has not challenged the dismissed petition,
Where are
removal
the
petition.
That order has to be seen. Mr. Padi, do you have that order with you?
Yes, yes, yes.
20th March 2008 order.
No, that order I didn't have.
Bro, you have to see that
But
order.
I have order of the cat match.
No,
No, that's right.
Unissued 5 page
But
30.
you have said that his husband of the petitioner has been removed from service without any
2008.
pensionary benefit. What is
Yes.
it? What is the tone and tenure of that order has to be seen. If any benefit can be given, family sympathy.
You get that order, Mr. Pari,
Yes, yes.
because he is not having that order. That is why she could not. The observation is also made in that line.
There is no order.
But fact remain that even the order was passed in 2008, 23 to 25, 2023, 2008, and she has died. He has died on 16/5/2017, my lord.
No, it's all right. But
All right, let us see sympathy.
by
Yes, yes.
2008,
I'll get it.
some relief can be granted. So that
Yes.
is how it may not
Yes.
get that pension if other benefits are there. He says that he was thereafter he was suffering and could not challenge it. All these things. So please produce that order.
Yes, yes.
Look on this. What is your name, madam?
S. Mishra.
What is your name?
S. Mishra.
S. Mishra.
On behalf of Tilajan Panigre.
S. Mishra.
कितना नंबर आइटम तिलोचन पानीग्राही एस मिश्रा अच्छा हार्ड मिस एस मिश्रा and counsel appearing through so
Puri
virtual High Court Puri. Stop. The writ petition has been filed by the petitioner Rajani Raula in the order dated 27/1/2018 passed by the Lani Central Administrative Tribunal, Cuttack Bench, Cuttack, in way number 244 of 2025. Where is your original application?
Lordship, I have not annexed the original application.
Why not?
Sorry, Lordship.
The Learned Counsel for the petitioner submits that she will file the original application. Any that was dismissed at the initial stage, at the admission stage, or what?
Yes, yes, yes.
Yes.
We have admission.
Okay. Stop. On perusal on perusal of the impugned order dated 25/6/2025, it appears that the husband of the petitioner was serving under railways as a section engineer, faced a disciplinary proceeding, and he was removed from his service by the order dated 2018. And further appears that there was no challenge to the said order dated 23/2008. However, after his death took place on 26/5/2017, a representation was filed by the petitioner seeking for family pension in her favor. And the opposite party, considering the representation filed by the petitioner, intimated her that since her husband was removed from the service by the order dated 20/2008, is not entitled to get any pensionary benefit. The learned tribunal has been further pleased to hold that no record was produced before the to show that no record was produced relating to the removal of the petitioner's husband from service on dated 23/2008. When we made a query to the land council for the petitioner as to whether he was is having any the copy of the removal order of the petitioner's husband with her, the answer was in negative. However, the grounds have been taken in the writ petition that the petitioner's husband was in service. କେତେ ବର୍ଷ service ଥିଲା ଆପଣ କହୁଛନ୍ତି କେତେ?
24 years.
Huh? How many years of service you?
24 years.
Huh?
Lordship, 24 years.
Where have you mentioned it?
In para 1. Page number 4.
Page number 4. Acha. However, in paragraph number 1 of the writ petition, it has been mentioned that the husband of the petitioner had completed 24 years of service in Southeast Railways, and therefore is entitled, the petitioner is entitled to get a pension. Let Mr. Parhi, Land Deputy Solicitor General, produce the entire service records of the petitioner and also the order dated 23/2008 by which the husband of the petitioner is stated to have been removed from service. Put up this matter. Mr. Pari, when will put up this matter?
After 2 weeks, man. After 2 weeks.
Okay, we want to just check whether he has served that 24 years or not. That
Yes,
is the
yes.
reason why we asked, and also the stop. Put up this matter on such and such date. We सप्ताह पर feeling. Yes, next.
Item 8.
Namaskar, sir.
May I please? Yeah, Lordship, in fact, this case may be referred to any other bench because Honorable Justice Mishra was a party. That is the railway issue, Lordship. Sambalpur Talche railway link case. So the bench of case should have listed.
This matter before some other bench in which one of us, Honorable Justice Mishra is.
Here, Lordship, item 8, 11, 12,
8,
14,
just a minute.
Lord.
8, 11,
12, 14,
14,
18,
18,
and 20.
20.
20. These all are similar matters
These
that
are
may.
Never ending.
Sorry, our
Never ending.
may prior settle ହେଇଲାଣି ତ batch ହେଇକି ଆସୁଛି ଅନ୍ୟ କୋର୍ଟରେ.
It should be settled ideally.
Yeah, of course. The only small issues involved that can be addressed. Well,
ଏମାନେ ଏଇ ସବୁ ଅଲଗା ଅଲଗା କାଉନସିଲ ଅଛନ୍ତି ନା?
ଆଜ୍ଞା ଆଜ୍ଞା all allow councillors. That name is also taken. The call list is there.
This should go to mediation and some. something should be
8,
done.
11, 12, 14, 18, 20. Yes, next.
Grateful, Lordship.
Item 9.
May it clear now then. Here is the case. can you let me pass over? I come to the court file. Because it is a case which was challenged by the Union of India. It is a very crux issue that Supreme Court said you extend the benefits to the employee, those have completed 16 and 26. But some people such come and find an application against which tribunal passed an order against Union of India. You have to allow everybody. And they are saying that once you extend the benefit to someone, everybody is entitled to get
content petition, Mr. Pari.
Yes, they have filed the contempt, my lord.
No,
Then it
that
is-
we have mentioned.
Yes.
What happened? The date was fixed earlier.
Again,
What
it was
is the
entered
status
to,
of the content petition?
this is pending, my lord. It is pending.
Can you tell us the date when it is now posted? Yes.
Again, it was 6 to 10
You are appealing
2025.
for whom?
Thereafter, I don't have.
Just a minute, Mr. Pari, there is a caveat here and you have not supplied the copy to the land council.
Oh, we'll file it tomorrow. Let him take a adapter tomorrow. Or,
Can you?
Just making it very about the contempt. Contempt was on 10th of this month.
Okay.
That's equally. They have filed this letter of the DG, but the DG has said that we should implement this order subject to outcome of the.
No, let your please. What is the content petition number? Tell us this.
That's when they have produced that order in the.
Content petition number
CP 59 of 2025.
That contempt number I have given there.
It is regionally.
CP 59 2025.
CP 59 by 25.
ଆଉ ଆପଣ ଯୋଉ କ୍ୟାବେଟ୍ ଟା ଫାଇଲ କରିଛନ୍ତି ତାର ନମ୍ବର
Cabinet, my number is 184. 184, right?
Mr. Trilochan Dutt, Land Council submits that he has filed a caveat petition, which is numbered as caveat petition number 184 of 2025. Let the caveat petition be placed on record. Stop. Mr. Pari, Land Council appearing for the Union of India, submits that steps will be taken by tomorrow to serve a copy of the writ petition on Mr. Roth, Land Council appearing for the caveat. After perusing the order dated 12/9/2025, when we made a query to the Mr. Pari regarding the status of the contempt number 59 of 2025, which is arising out of way number 288 of 2021. Which is the subject matter of challenge before this court in the writ petition. It is told to us that the contempt petition is now sub judice. Stop. However, Mr. Roth, Land Council, files a memo wherein the letter dated 10/10/2025 issued by the Assistant Director General (PE-1) to the Chief Postmaster General, Orissa Circle, Bhubaneswar, has been annexed, wherein it has been stated as follows. Quote, you purata quote कर दूँ, है ना? The memo along with the letter dated 10/10/2025 is taken on record. Put up this matter. केबे रखिवा Mr. Pari? Copy आपण काली भीतर देई देबे writ petition.
Tomorrow I'll serve the copy to my
नहीं केबे रखिवा कौन तो let him.
Next
And,
week.
About the letter which he has referred to, that also you've taken because in the CP, after the filing of that contempt petition, a letter has been issued for complying the order. It is by your own authority. So perhaps
It is not known to me.
no, you are. Why did you give it? It's a copy of the letter dated 10/10/2025. Be served on the land Deputy Solicitor General. By tomorrow also you serve the copy. So you also take instruction on this
Yes,
later.
ma'am. Yes, ma'am.
So why unnecessarily this retweet?
Yes.
Put up the, so let it then let it come on 27th. You take instruction because if
Yes,
your
yes.
authorities is likely to comply the order because they have stated that comply the order.
Is it possible by on 27th or 29th?
29th it will come.
Yes, fine.
Put
Yes,
up
fine.
this matter on 29th of October 2025. The Land Council, Deputy Solicitor General shall obtain specific instruction on the letter dated so and so, which is produced by the Land Council for the gathering.
May I pray, my lord? This, in the meanwhile, lordship may protect us about the content proceeding.
No, content fiction के भी
They are making a prayer to
Yes,
comply
they are
with
fixing
order,
the
and
date.
High Council is saying
no, no,
that they-
ଆପଣ
they-
ପୁରା
they-
କହିଲେ
and
ସେଟା
it
ଲେଖା ହେଇଛି
is-
କଣ ଆପଣ ନିଜେ ଲେଖୁଛନ୍ତି ଏଇଟା ଇନଷ୍ଟ୍ରକ୍ସନ ଦିଆ ହେଇଛି ଯେ ତାକୁ କମ୍ପ୍ଲାଏ କରନ୍ତୁ immediately.
That is their instruction.
That your letter has been produced before the Central Administrative Tribunal, which is now he's given a memo. So now you are interested to comply. So this writ petition would be accordingly disposed of because that will become infructuous. Once you are
Yes.
ready to comply the order, where is the question of challenging the same again? So take instruction on that later. We are keeping it, as you said, on 29th. Yes.
Yes, my lord. Yes. Bless.
Item 13.
Not challenge the order dated 8 January 2025, passed in OA 776 of 2023, and order dated 18 August of 2025.
Why have you not filed copy of OA counter? Nothing is filed.
Repeatedly, we are telling that whenever you are challenging the
Challenge.
order of the London Central Administrative Tribunal, please file the entire pleadings which neither you have filed the original application nor as it appears
Annexer 3.
3.
is the
This order
copy of the impugned order. Are you not following what we are saying? Original application जोटा कि आपण फाइल करछंती तार कॉपी फाइल करंतु any counter affidavit was filed.
No, my lord. This is listed past time. We have not filed the
Petitioner.
ନାଇଁ ଆମେ ଏଠି କହୁଛି ଟ୍ରାଇବୁନାଲ
Tribunal,
କାଉଣ୍ଟର ଆଫିଡେଭିଟ୍ ଫାଇଲ ହେଇଥିଲା
Kepa file it.
ଆଉ ସେଟା ଫାଇଲ କରନ୍ତୁ.
File courts. Annexer 3.
Mr. Counsel, Annexure 3 is the impugned order.
Against it and filing this petition.
You are not following.
Annexure 3 ଟା ହଉଛି impugned order. ଗୋଟେ ଅରିଜିନାଲ ଆପ୍ଲିକେସନ ଯୋଉଟା କି ଆପଣ ଫାଇଲ କରିଥିଲେ ତା ଦେହରେ ଏଇ ଅର୍ଡରଟା ପାସ୍ କରିଛନ୍ତି ସେଣ୍ଟ୍ରାଲ ଆଡମିନିଷ୍ଟ୍ରେଟିଭ ଟ୍ରାଇବୁନାଲ. ଯୋଉ ଅରିଜିନାଲ ଆପ୍ଲିକେସନ ଆପଣ ଫାଇଲ କରିଥିଲେ ତାର କପି ସେଣ୍ଟ୍ରାଲ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଯୋଉଟା ୟୁନିୟନ ଅଫ ଇଣ୍ଡିଆ ତା ଦେହରେ ଯୋଉ କାଉଣ୍ଟର ଫାଇଲ କରିଥିଲେ ତାର କପି ଆପଣ ଯଦି କିଛି ରିଜଏଣ୍ଡର ଦେଇଥିବେ ତାର କପି ସେ ଯୋଉ ପ୍ଲିଡିଙ୍ଗସ ଗୁଡାକ ଆମର ଦରକାର ତାହେଲେ ଆମ ଆସେସମେଣ୍ଟ କରିବାକୁ ସୁବିଧା ହବ ସେଇଥିପାଇଁ ଆମେ କହୁଛୁ ଆପଣ କହୁଛନ୍ତି ଫାଇଲ କରୁଛି ଫାଇଲ ଲେଖନ୍ତୁ the Land Council for the petitioner seeks some time to file the entire pleadings before the Land Central Administrative Tribunal in OA number 50 of 2025. କେବେ ରଖିବା କୁହନ୍ତୁ?
16.
Put up this matter on 16 ଦେଇପାରିବନି ଗୁରୁବାର ଦିନ ଅଲଗା ବେଞ୍ଚ ଅଛି ସୋମ ବୁଧବାର ଏବଂ ଶୁକ୍ରବାର କୋଉ ଡେଟରେ ଆପଣ
See, 28th or 29th is convenient better. Yes, sir.
Put up this matter on 27th of October 2025. Yes.
Item 15.
15th as for processor of.
Yeah.
Hello.
Mr. Khuntia, which order you are challenging?
Order of the Central Administrative Tribunal at Annexure 2, page 160, my lord.
Any no counter affidavit has been
No,
filed?
no count.
Okay.
That means first time. Then still first time.
Original
No, that is why we saw that you have filed only the original application, but that's why we made a query to you that.
No, my
So,
no counter is filed.
What was your challenge before the Land
Challenge,
Central?
my lord, that I will bring my lord's notice.
What is the relief sought for?
Yes, madam. I was dismissed from service.
No, come to that particular page.
Yes, ma'am.
Page, paragraph number 8, na? Relief sought for.
Yes, madam.
Which number page is that?
If you can find it from page 32.
32, huh?
My.
Was the office order dated 19/8/2011 under Annexure 1, A by 1, right?
There are just that is Annexure A by 1. All
A by 1, acha. ठीक है, पढ़ दियो तो Annexure A by 1 ना?
That you also can find it from page 33.
हाँ, no 33 ना 35.
33 ना.
अच्छा हो, A by 1 टा. हमको पेज रे दिया है कि 35 बेली. इटा 35 for I. A by 1 टा पढ़ो तो दियो.
So, I am reading last portion, my lord.
मैम मूड पढ़ो तो.
Yes, sorry. Whereas Mahendra Marana UDC of Office of the Deputy Chief Labour Commissioner Central Officer has been convicted on a criminal charge under Section 7 and 13(2) read with 13(1)(d) of Prevention of Corruption Act 1988 and has been awarded a sentence to undergo arrest for 6 months and to pay fine of ₹1,000. That is 1 month more under Section 7 of PC Act 1980 and to undergo arrest for 1 year and to fine of ₹5,000 rigorous arrest for 3 months more under Section 13(2) read with Section 1(d) of PC Act 1988 in case number. And so in the Court of Special Justice CBI Windsor, both the substantive sentences are to run concurrent. And whereas it is considered that conduct of the said Mahendra Marana UDC of Office of Deputy Chief Labour Commissioner Central, which has led to his condition, is such as to render his further detention in the public service undesirable and warrant imposition of a major penalty. Whereas Mahendra Marana UDC was given for making representation on the proposed penalty of dismissal from service by this office letter number 70, so and so dated so and so, and also he was given an opportunity of personal hearing on 19/8/2011. And whereas the said Sri Marana submitted a written explanation by the letter dated 16/8/2011 and was personally heard on 19/8/2011. The written explanation and personal hearing were duly considered by the undersigned. Now, therefore, in exercise of power conferred by Rule 19 of the Central Civil Service Classification Controlling the Appeal Rule 1965.
Central Services Division. Yes, read it on.
The undersigned is hereby removes the Mahendra Marana UDC officer of the Deputy Chief Labour Commission Central Windsor from service by imposing the penalty of removal from service with effect from 19/8/2011.
So what happened to the criminal appeal?
Yes, ma'am. That I have annexed.
You got acquitted.
Yes.
On that basis, you sought reinstatement. You have been reinstated.
Back
wages is not given.
Yes.
That's what you have given.
That's the short point. Only that
he has been reinstated by along the way. But back wages, notional fixation of.
No, yes. That the judgment of the criminal appeal at page 65 annexed A.
Acquittal is on merits or on technical ground?
That I have given that judgment, madam.
Where is that?
Technical ground.
No, not on. You'll see page 65 that I have given that judgment. That my lord's judgment.
65.
My.
Read about more judgment.
Yes, I said.
I don't want to move Suniola Tigo. I should go to this some other day. All by acquittal करते अपन.
You can't get all the relief from one court. You have to go to some other court.
I said that judgment from my
lord. This matter before some other.
Go to some other way.
Yes.
No person. Then next.
Item 16.
Yeah.
This is the last. The action is that
you find the judgment with regard to provide the remunerative calculation. The non here is
The Land and Council who used to appear for Mr. Maharana used to appear for this executive engineer electricity.
Mother.
Can put a copy. You have to give a copy to him. He was here.
In the morning,
after. There are some matters also. Give a copy of one. We'll also mention his name in the cause list. The Land and Council for the petitioner. Files decision of this court. ଗୋଟେ ନା କେତେ ଅଧିକା decision ପାଇଁ କରିଛନ୍ତି
SODL measure.
Some orders କରିଦିଅନ୍ତୁ, some orders passed in WPC number, some writ petitions, no? With a memo which are taken on record. No? Since Mr. Lalit Maharana used to appear for the opposite party, number one, let a copy of the writ petition be sought on him by day after tomorrow. By day after tomorrow,
along with memo.
Along with the memo, citations placed today. Put up this matter on 22 तारीख 22nd of October 2025, indicating the name of Mr. Lalit Maharana in the cause list. Any difficulty on
24th.
24th, all right, 24th. 24th of October. Board member.
Father of the petitioner died.
Criminal appeal?
Yes.
Kebe expert.
9 तारीख.
After lunch near some town instruction. Special notice.
Where is the copy of application?
My lord, right now I'm sorry.
Puthana.
Serogod Thana.
Opposite the front, no left.
Just one matter 39 में interim order because
Not taking up the matter.
ଆଜି ପର୍ଯ୍ୟନ୍ତ ଥିଲା କି ଏମିତି ଥିଲା ଆଜି ପର୍ଯ୍ୟନ୍ତ?
yes my lord.
ଯଦି ସେମିତି ଥିବ ତାହେଲେ ଡେ ଆଫ୍ଟର ଟୁମୋର ରଖିନି ଆଉ ଯଦି ଥିବ ନେକ୍ସଟ ମାନେ ସେମିତି କିଛି ନଥିବ ଆଜି ପର୍ଯ୍ୟନ୍ତ ତାହେଲେ କିଛି ଲେଖିବା ଦରକାର ଯଦି ଟିଲ୍ ଲେଖା ହେଇଥିବ
39 ନା
Till next date ଥିଲା my lord.
ନେକ୍ସଟ ଡେଟ୍ ଆଜି ତ ନ ପଢିଲେ
next date
ନ ପଢିଲେ ଅଟୋମେଟିକାଲି ପହରଦିନ ଆଜି ନା କିଛି ଆମେ ଲେଖିଥିଲେ ହେଇଥାନ୍ତା ତ ନେକ୍ସଟ ଡେଟ୍ ତ ଆଜି next statement list hella, but we are not taking up the matter. So it will go to day after tomorrow. What is the question of any vacation of that interim order? It will remain as such.
My lord,
I may be pardoned, my lord. Is a life convicted, my lord, as petitioners are, all the appellants are life convicted. My lord. So,
What do you want?
we did like this to the company.
Huh? What else you want to do? Huh? What do you want?
This is a matter, my lord, a appeal matter, my lord.
What do you want? Why are you filing the memo? For bail application?
Bail application.
Give it to them. Here. Here.
Due to urgency, and let me mention,
Yeah.
my matter has been listed as item number 28
Yeah.
of the first list for the first hour.
Huh.
I could not get a mention because I was of the view that the matter will reach. It could not be. Urgency that the property is going to be auction tomorrow.
Day after tomorrow we list. Yes.
Auction is going to be held
Been
tomorrow.
successfully for more than 14 years.
Yes. Yes. All it matters.
Weekly list, item number 1.
Convicted of the session 498 302 IPC and for DPA, my lord. The sentence to my lord.
Hard admit call for the trial court records. Interim application for bail and stay lesson to be considered after receipt of it. In the meantime, land council shall supply deposition copies of all the witnesses to the land council for the state. Yes.
Item 2.
May I please, the convicted under section of IPC, arrive for life matter. Yes.
Admit for the trial court.
I will file IHA letter, madam. IHA, I will file letter.
Is it necessary to mention it?
No,
Is it?
Item 3.
My lord, the appellant has been convicted under section 302 by 34 of the IPC and sentenced to undergo life imprisonment and to pay a fine of rupees 30,000.
Why are you moving this up admission matter? Why are you not allowing this junior to move the admission matter? What they will learn? Admission is a matter of right. At least allow the junior to place the case. They will get confidence. Right? Or admit like the first one is next.
Item 4.
Like depositions are annexed with the brief.
Okay, deposition ta kati do.
What my lord, DCR is available in the case record, my lord. Paper will be prepared. I will have.
Which one?
4 item 4. I have appended in 2015, my lord. My decisional code. If paper will be ready, my lord, then will have.
The man is in custody.
Custody, my lord. Since my lord 15, I was engaged in this case, my lord. But TCR are not available by the time. No copy is available for the I have not filed bail application. There can none appeal.
What about the status now?
That copy will be. The proposal also not with us.
No, we want to know the status of the, because the date of forwarding Lekhaji final form day 6/12/2013. So it is about more than 11 years and 10 months for Ilani custody. So the status कौन था तो?
Eyewitness there?
Man. No eyewitness, my lord.
Who jail এটা আছে? Who jail এটা আছে? এটা business person
special jail ভুবনেশ্বর
special jail ভুবনেশ্বর account of appear করবেন 500 করবেন immediately খবর দিন yes next
Item 5.
2011 मसीहा बना पूजल नहीं जेल प्रिजनर्स प्रिजन असते Bonai special subject. That one to pass over. Next.
Item 6.
Great legal office. I'm appearing on behalf of Mr. Patnaik in this case also. I will file IML. Let it come next week.
Will you file the IA?
I will file IML.
No, why you are, the brief has been entrusted
Not
to
of Mr. Patnaik. On behalf of Mr. Patnaik, I am addressing you.
परिधि जेल का ये
For the entrusted to.
Chaudhara. He cannot entrust the brief to you, Mr.
My lord, he will conduct, my lord. He
Jail criminal appeal we have entrusted to Mr. X. X cannot entrust it to Y. Either he will do it or he will leave it so that we can entrust to somebody.
He will do it, my lord.
Chaudhar could log pass over. Next.
Item 7.
Pujil. Bhawanipatna. Bhawanipatna logan. Pass over. This matter has been entrusted to Mr. Moon. So ask Mr. Moon to argue the matter. If he says no, we can give it to somebody else. Yes, sir.
Item 8.
It is concerned, my lord.
While Anet has to take inspection.
That's okay. It is concerned we take some more time. That is the matter regarding the premature bail. That we have sent the letter, but we have not received the instruction. I play some more time to.
Premature release.
Whether the premature bail will be considered.
The order was passed on 29/2025.
My lord.
And the application is dated 29/2022.
They are giving the report that in the month of February, they are given report that they have 13 years in the custody. They have not completed 14 years. That's why my lordship directed to take the instruction after completion of the 14 years, whether is a premature application will be considered.
Now 14 years is
Yes,
complete.
my lord. That's why we pray for more time too. They are not giving the report.
Certain whether process has been started. Recommendation.
No, when you send this order, copy of the order, to which authority you have sent?
On 26/9/2025, I am sent the letter.
Just a minute.
26/9.
The order is passed on 29/2025. You said it on 26/9/2025.
My lord.
To whom?
To the Superintendent Chaudhar.
So ask him to appear. जो आसी बना दिया ये जो मैटर है फोन पे appear करूँ Superintendent pass over from.
Item 9.
On behalf of Mr. Aditya Mehta, my lord, Mr. Aditya, her father expired, my lord, and he fell from me.
What is the order of
Father expired.
Just a minute. Conduct of responses and trying to verify the case. Yes, what is the custody certificate? How many years is in custody? Actual period 11 years, 7 months, 24 days. On remission 2 years. So it comes to 13 years, now 14 years. 14 years. So how many times the bail application has been rejected earlier?
Still not here.
What is the judgment? How many appellants are there? Prisoner's petition has been filed by Govindo Hembrom. 3 persons are facing trial. Govindo Hembrom, Govindo Murmu. 376, 302, 201, 34. Was 302, 376. Beyond all reasonable doubt, it has been proved. Okay. Computer. Which jail he is now? Baripada. What was the age of the at the time? Baripada. Judgment is the 20 years. 32 years. But he also told them. What is the difficulty today?
Father expired. We want to be material. She wants to be material.
So, when she is likely to return?
Now, yesterday he went to Allahabad for
No, when she has suggested the date to you.
after 2 weeks.
The other two accused persons named Govinda Marandi and Govinda Dharma, though have been charged under section 7 also, there is no evidence of record.
There 3 persons who beat up.
Murmu, अच्छा ये ऐसा
Govinda Dharma, 3 persons who beat up.
You know, I could have been. You know, should be the
council is not here.
Not going to Allahabad.
Other day.
Mention is made by Mr. Vijay Kumar Raghav, Grand Council appearing for Mrs. Aditi Hota, that there is bereavement in the family of Mrs. Hota, and the matter may be taken off in the week commencing from 27th of October 2025. 27/10/2025. Yes.
Item 10.
May I please? Directed my government to take inspection. I have taken inspection that PW5 in matter already died in the 2019 year old. The PW5 is the sole life of the offense and on the
Found guilty under transfer, killing his father and mother.
Yes.
Killing his father, as a mother of the petitioner was examined as eyewitness. He was given some kind of inspection at the start of the mother of the petitioner. As in the case, there is likelihood to her life. कौन ଆସିଲା?
PW, mother is died in the year 2019 year old.
What is the document?
And then senior thing.
From whom you got that information?
I got information from this one. And then
The PW5 dead.
So how many years you are in custody?
losses 10 years.
Just see that. Your name is
Dr. Sam.
Dr. Sami. P49/2015.
Yes, Your Lordship.
You have never been released on bail during trial.
No, Your Lordship.
After which also is produced. Okay. So it's a case based on the eyewitness
Direct,
statement of
P5, mother.
Mother, Your Lordship. Due to some liquor.
So it's about you have completed 10 years.
10 years, Your Lordship. Only something is my wife is dead, my son, only son also dead, Your Lordship.
Your age was at that point of time 35.
35, Your Lordship.
IA number 262 of 2024. There is an application for bail as per the order dated 25/8/2025. The Land and Council for the state has produced the written instruction dated 5/10/2025 received from IIC Sohela Police Station to the effect that mother of the petitioner was examined as the sole eyewitness to the occurrence and supported the prosecution case as PW5 as PW5 and supported the case is no more. And the death certificate of the mother of the petitioner has been produced, which is taken on record. The Land and Council for the petitioner submits that the petitioner was taken into judicial custody on 4/9/2015, and he was never released on bail during trial, and as such, his custody period is more than 10 years. And the paperwork has not been prepared, therefore there is no likelihood of the matter being taken up for hearing. Therefore, the petitioner bail application may be favorably considered. Land Council for the state, on the other hand, oppose the prayer for bail and place the evidence of PW5.
PW5 and PW4 leading to discovery.
PW5 was stated that the appellant killed the deceased, bracketed father of the appellant, with a cautery by dealing blows. Mr. Naik further faced doctor
My lord, Dr. PW8
further faced the evidence of PW8, the doctor who conducted postmortem examination and who find that the cause of death was hemorrhage and shock due to caught injury to the large vessels of the neck. He further placed the evidence of PW4. He is leading
to discovery.
He is a witness to the leading to discovery of the weapon of offense.
That is cautery,
which was produced before the doctor, bracketed PW8. And when examining the same, submitted that the injuries noticed on the person of the deceased would be possible by the said weapon. Considering the submission made by the Land Council for the respective parties, in view of the eyewitness account coupled with the postmortem report findings and available material in report, I will not incline to release the petitioner on bail on merit for taking into account his period of detention in judicial custody for more than 10 years. And since there is no likelihood the appeal being taken up for hearing in the near future, in case the ratio laid down in the case of Lecky versus Swans, 3 months bail grant.
Item 11.
May I please alert you? What is to be coming by the result from the
May I please alert you? Order that 25/8/25, my lordship calls for that instructions to whether the appellant is following up.
My lord, the appellant convicted in G. Udaygiri PS case number 18 of 2011 for commission of offence under section 341, 307, 506, 34 IPC and sentenced to undergo RI for 5 years. In appeal, 307 was acquitted from the charge under section 307 and sentenced to undergo RI for 2 years. After serving 2 years sentence, he released on bail in April 2017. Thereafter, he committed the present case.
No, what we wanted that that was the order passed by the appellate court. So
The sentence serve कर दी पड़े इसला.
हाँ
Sentence का serve करी कैसे?
अच्छा तो हमने revision of
Yes,
file
no.
करना दी थी. So what is the offense here?
Offense, my lord, did not do. And yes, is based on circumstantial evidence. And
How many years in
custody more than 7 years, 10 months. Custody since 13 to 2017.
Where is that final form?
Custody since final form.
Custody since the 30/12/2017. That is mentioned in the judgment.
ठीक है ठीक है. 30/12/2017.
My lord.
अच्छा. Circumstantial evidence or case?
Circumstantial evidence. No eyewitnesses there, and out of 21 prosecution witnesses, almost 9 witnesses are turned hostile. And the most important thing is the informant himself.
What are the circumstances?
Circumstances, my lord, only PW 7 and 8 saw on the last night that present appellant came around that house.
No, my lord, that apart, my lord, apart from last in theory, extrajudicial confession leading to discovery and doctor evidence.
Leading to discovery of what?
Leading to
dead body or the weapon of offense?
Weapon of offense. Hattori.
That Hattori is not examined. No chemical examination report is available in just not exhibited.
And confession before whom?
Extrajudicial confession before PW 10.
PW 10, who is PW? Who is PW 10?
That is, I will say that is not so pre-consent. By that time, he was apprehended.
No, I do not know anything about the case. PW 10?
Cross examination. Cross paragraph 2. It is a fact that I was in jail in connection with murder case of my wife. It is not a fact that during my stay, Amrut was also in Ballyguda jail after conviction and was released from jail prior to release of Amrut.
The hostile na who extrajudicial confession. Like प्रथमे खाली line टा it is a fact. तापर सब गुड़ा ताला it is not a fact. It is not a fact that during my stay, Amrutlal was also in Ballyguda jail after conviction, and I was released on bail, so and so. And after my release, once so release.
My lord,
And after, so everything he has denied.
That happened, my lord, leading to discovery.
Leading to discovery of
Period
what?
16, Hathudi. Paragraph 4. Page 86 of the paper book. IAC Sethi Babu, G. Udagiri PS had called Jharn Sahu and myself to police station where Amrutlal was present in PS. The accused confessed his guilt in my presence and he has killed the deceased by means of Hathudi blow and kept the Hathudi and his wearing apparels below the dead tree near the playground of Panga Naju.
So one Hathudi was seized.
Yes.
At the instance
of the.
How have you proved that it is a weapon of offense? If it has not been sent for chemical examination, no bloodstain. Have you the KC report is there?
No, my lord.
So,
03 hours.
how do you link that Hathudi to the offense in question? Unless you found that it contains bloodstain, that bloodstain matches with the deceased.
Yes.
Otherwise, it would be a simple recovery of a Hathudi at his instance.
That Hathudi was produced in court. MO1 is the said Hathudi.
It's all right, but let us say one Hathudi was seized. So how do you get the link of that?
That was sent for chemical examination, but report in the paper book report is not there.
So no. In the judgment, whether the C report has been marked as an exhibit.
No, my lord. Judgment is not exhibited and the report is.
Forwarding the report of the exhibit. C report as
So खाली गोटे हाथुड़ीटा रिकवरी होला बाकी एक्स्ट्रा जुडिशियल कन्फेशन रो होस्टाइल हेगला लास्ट सीन की कोची
PW 7 and 8
And out 7 and 8 on hostile.
Just a minute. PW 7 and PW 8. PW 8 hostile हेगला
My lord.
अच्छा PW 7 tal कौन केला
At about 12 midnight on 19/12/2017, I went to attend call of nature to our village school field. Chandravati Pradhan also went with me to attend call nature in that night. While
Chandravati की ऐसी PW 8.
PW 8 my lord.
Wrong. While
returning, both of us took note that Jinlal Amrutlal was coming from the house side of Hasina.
Amrutlal appellant.
Appellant.
From
Hasina.
the house side of Hasina.
Towards his house with a hammer at his hand beside their well. Beside their well.
ତାପରେ
evening.
ତା ଘର ଆଡୁ ସେ ଆସୁଥିଲା ଗୋଟେ ହାମର ଧରି ସେଟା କଣ ହେଲା ଏଟା ଲାଷ୍ଟ ସିନ୍ କେମିତି ହେଲା
ଲାଷ୍ଟ ସିନ୍ ହଉଛି ସେଦିନ ଇଭିନିଂ ରେ ନେକ୍ସଟ ପାରା ଇନ୍ ଦ୍ୟାଟ୍ ଇଭିନିଂ ଆୱାର of 19/12/2017, I found Hasina, Amrutlal, wife and sister of Amrutlal, and Susoma were sitting beside fire.
କେତେ ଲୋକଙ୍କ ସାଙ୍ଗରେ ଲାଷ୍ଟ ସିନ୍ ଥିଲା ତ 5 ଜଣ ଲୋକ ହେଇଗଲେଣି. It's not that those two were there. ଆପଣ ଏଠି ପଢିଲେ ପରା ହସିନା ଥିଲା ହସିନା ହଉଛି deceased Amrutlal ହେଲା petitioner.
Yes.
ତାପରେ wife and sister of Amrutlal ସେମାନଙ୍କ ସହିତ ବି ଲାଷ୍ଟ ସିନ୍ ସୁଷମା ସହିତ ଲାଷ୍ଟ ସିନ୍ 5 ଜଣ ଥିଲେ. How do you say that it was only the last scene with the appellant?
Only PW 7 he has seen the very
how can you sustain a conviction on this evidence and he is in custody for
more than 7 years.
Are the learning counsel for the petitioner, learning counsel for the state, the learning counsel for the petitioner submits that the petitioner is in judicial custody since 30/12/2017 is based on circumstantial evidence, and though the prosecution examined PW 7 and PW 8 to substantiate the last scene of the petitioner in the company of the deceased, Hasina, but PW 8 didn't support the prosecution case for which he was declared hostile. And PW 7 has simply stated that the deceased was found not only in the company of the petitioner, but also in the company of other persons. He further submits that the witnesses to the extrajudicial confession, that is PW 10, has not supported the prosecution case, and so far as leading to discovery of the one Hathudi is concerned, which is deposed to by
PW 16 and 17.
PW 16 and PW 17, it has not been proved that the said weapon has got any link with the crime in question, in as much as there is no evidence that any bloodstaining was noticed on the Hathudi, or any C report was proved by the prosecution after the examination of the Hathudi in question. It is the further contention of the land council for the petitioner that in view of the nature of evidence available on record, there are good chances of success in the case, and balance of convenience is in favor of the petitioner. And since it's a jail criminal appeal of the year 2023, and there is no likelihood of the appeal being taken up for hearing in the near future, the bail application may be favorably considered. Stop. Land counsel for the state, on the other hand, oppose the prayer for bail and place the evidence of PW 7, PW 16, considering the submission made by the land council for the 16 and 17, considering the submission made by the land council for the respective parties, absence of any direct evidence in the case, nature of circumstantial evidence on record, period of detention of the petitioner in judicial custody, absence of any chance of early hearing, we are inclined to release the petitioner on bail, stay realization of fine.
Item 12.
Case of a double murder. The petitioner is in custody. So it's 12/9/2019. Bar no 2019 on the date of arrest.
Case of direct evidence.
Yes, PW 4.
PW 4.
PW 4 of the claim.
Paragraph 2.
Orderly.
The occurrence took place about 2.5 years back at night on Saturday in the house of the deceased person, and I was also present in the said house and was sleeping. The accused has abducted my wife prior to occurrence, and he has threatened me over phone and told me to take back my wife or else he would kill me, and I refused to take back my wife. Thereafter, I gave the phone to my father-in-law, who has refused to take his daughter, and the deceased also, and the accused also threatened to kill him if he did not do so. Then both my father-in-law and mother-in-law refused to bring their daughter back to the house. On the previous day of the occurrence, the accused drove away my wife from his house. On the night of occurrence, I was sleeping in the house with my son in a room and had locked the room door from inside. I heard noise and woke up, and when I tried to open the door, I found that it was locked from outside. Then I opened the window of my room facing the veranda, where both my father-in-law and mother-in-law were sleeping, and I saw the accused there, who was holding a hammer and assaulting my father-in-law and mother-in-law with it. Then I closed the door and raised halla to call the nearby people. Hearing my shout, my villagers Rabi Munda and Sali Munda came running to the spot, and thereafter Govinda Munda also came. The accused fled away from the spot. Thereafter the door which was locked from outside was open, and I came out of the room and went to the spot and saw that both my father-in-law and mother-in-law had sustained severe head injury with heavy bleeding and both were dead.
तो ସେମାନେ ବାରଣ୍ଡାରେ ଶୋଉଥିଲେ ଯୋଉ ଦିଟା ଯାକ ଡିସିଷ୍ଟ ଇଏ ଥିଲା ଗୋଟେ ଘର ଭିତରେ ୟାର ଘରର ବାହାର ପଟୁ କବାଟଟା ଦିଆଯାଇଛି ଦେଇ ଦେଇକିନି ଇଏ ଝରକା ଭିତରୁ ଦେଖିଲା ଇଏ ତାକୁ ଇଏ କରୁ This evidence has been accepted by the trial court. କେବେଠୁ ରହିଛନ୍ତି
12/9/2019
ଆଉ ଥାନ୍ତୁ ପରେ ଜାନୁଆରୀ ଆଡକୁ ରଖିଛନ୍ତି Grand Counsel for the petition is 6 for an adjournment, January 2026. Yes, next.
Item 13.
Prisoner's petition of flag A. कौन सा? तो सब तरीके से ठीक है. Yes, Mr. Mishra.
May I please read matter? The case of prisoner of 2 minor, eyewitnesses are there, madam.
Have the judgment of single murder or?
Yes, madam.
It's about for
I'm custody since 2020, 5 years, 8 months.
29/1/2020. What is the name of the deceased?
Janni Sanangi. She's the stepmother.
Stepmother of the appellant?
Yes, ma'am.
Is the eyewitness?
Eyewitness is
It will 13 and 14.
14.
13-14.
13 and 14.
How doctor ke?
Dr. PW12.
देखिए वो eyewitness है. Zero. Hold on to take.
The occurrence took place about 3 years back at 9 p.m. The deceased was aunt, Mausi of the accused.
Who's mouse?
I had got a block from accused. As per custom, I had to feed the accused. On the date of occurrence, I went to the house of my daughter, Mukta, with 2 kg chicken and 2 kg rice and cooked food there. Thereafter, I took the chicken and rice and went to the house of the accused, and while we were eating, there was a quarrel between the accused and the deceased. So the accused gave a blow on the backside of the neck of the deceased with a tangia. The deceased sustained bleeding injury and died. I returned back to my daughter's house out of here. The PW13 and the accused both were eating together.
But 14 is
The wife of the PW13.
And they were examined after 5 days of the incident.
On there are किसी बात पर जाएंगे.
Yes, ma'am.
What was it?
The PW13 is saying due to darkness.
पाखिर बसी खाऊथरे darkness.
No,
relation no और
darkness. I cannot say the number of rooms present in the house.
तेरा कौन?
PW14 saying there are 4 rooms. Whereas I was saying 1 room.
कौन main कथा कौन को chapter
delay काहे कहला से कथा
Delay after 5 days of occurrence there.
No, why there was delay? That was not
Yes.
काहे तो क्रॉस एग्जामिनेशन सेटा किछि आसेनी.
FIR किए देला?
FIR is one deceased ro bhai.
FIR against unknown person?
No, madam.
How?
FIR against appellant.
परिपचन से तार सापत मागु संगे रहउतले गतकाली आम ज्वाई पाखुर सातटार खबर देले मोर भौणी रक्ताक्त अवस्था रे घरे मरि पड़ी. मु तापर तांग घर को जाई देखिले मोर भौणी रक्ताक्त अवस्था रे पड़ी छि. तांग घर भीतर मरि पड़ी. मोर भौणी को तार साबत पुओ तो आंसो टांगिया रे हानि के मार दिया. अच्छा वो से जो दीटा विटनेस कोचंती PW13 and 14 they were examined
after 5 days.
How do you say 5 days?
They are stated, madam, in their statement.
वो आयोग को पचारते नहीं क्या एग्जामिन
आयोग को chapter
नहीं आयोग कितना बताइए आयोग कितना बताइए
आयोग में 21 PW21.
Two line টা দেখি examine your date of examination. Where is that question? Where have you put questions that these witnesses were available and in spite of that he did not examine? So deliberately they delayed in giving the statement and therefore there was every chance of false implication at a belated stage, posing themselves as eyewitness to the occurrence. These questions kind.
No.
Unless you put questions to the witnesses, unless you put questions to the IO, how you will argue the matter that 5 din delay?
Doctor testimony is also followed. PW50 cross examination. Sorry, paragraph 50.
Paragraph.
Say I that occurrence taking place in the house, but the accused and deceased were staying in that house only one room. It is not a fact that the small house is surrounded by stony surface. It is not a fact that door of the house. It is not a fact that they have not made any confession.
January 26th. Yes, next.
Item 14.
Case of double murder, Dr. Kapul were murdered by the
Eyewitness achandi?
No, there was no eyewitness to the occurrence. All of the circumstances witnesses, PW3 the informant and PW12 is the wife of the informant.
Evidence kon achi kuhନ୍ତୁ? Eyewitness nahanti, evidence kon achi circumstantial?
Circumstantial evidence was there. PW12 only stated that while he was traveling with in a car, he found that the maid servant, namely Tikina, along with the other 4 accused persons, were coming from their house.
Come to the evidence, paragraph 7. ଆପଣଙ୍କ ନାଁରେ 13ଟା circumstance jotted down କରିଛନ୍ତି. Trial court. Page number 14 of the trial court judgment.
The custody sins?
Custody since
2015.
Accused Tikina was working in the house of deceased couple as maid servant. Tikina মানে পুরোটা না জিওটা?
জিও।
এটা জিওতে?
আগে।
His husband also accused.
Wait.
Jivan.
Tikina কাই? এটা আমার লেখা হয়েছে item number 14 তো? টিম্পা লেখা হয়েছে কিশোর?
না, টিম্পা another accused.
Tikina alias Subhadra.
কাই নাই তো? আউডা জি কোন
Page number 10 you will
নিনি কোন ফুলসরি বেরা?
Nichi alias Fulsari Behra and page number 5.
3টা appeal ଅଛି, jail criminal appeal.
କାଇ ଦିଟା ତ ଲିଷ୍ଟ?
ଦିଟା ଅଛି, ଆଉ ଗୋଟେ ଲିଷ୍ଟ ହେଇ ନାହିଁ. টিম্পা alias কিশোর চন্দ্র বেହେরার ସେଥିରେ sole ଜଣେ accused ରୁ appeal file କରିଛି, that is JCRL 76 of 2024. ନିନି alias ଫୁଲସାରୀ ବେହେରା and MD କମଲ ଖାଁ JCRL 80 of 2024. ଟିକିନା alias ସୁଭଦ୍ରା ଜେନା and ଜୀବନ alias ଜୀବନ ନାୟକ.
କଣ ଏଟା ବାହାର କରିଛି? Just a minute. ଏଟା କଣ? Paragraph कितने में देखते हैं?
Paragraph 20, paragraph 7.
7, हाँ. Accused Tikina was working, gala. CDR of the accused persons, namely Tikina and Timpa, show that they were in contact with each other, gala. This is Susama visiting the temple and daughter-in-law of so-and-so seeing the accused person near the house of the deceased person while she was coming to wish her mother-in-law. Deceased couple was seen lying dead in the occurrence house. Opinion of the doctor, so evidence of the doctor death is unnecessary. Absconding of the accused. Apprehension of the accused more than so-and-so. Recovery of the weapon of offense, shepherd, so-and-so, from the place identification of the accused named so and so, details told inside Jharpara jail, but seen and while she was going to some property wine, availability of chance fingerprint on the spot and matching the fingerprint of accused Kamal Khan and Kishore Behan. यार अच्छी आपनकर ये दुटा चांस फिंगरप्रिंट रही आउ पाखापाखि थिले आपण गुडाक सेठी मत
Soon after the occurrence, it is alleged that PW12 had seen the accused to all the accused persons while he was moving on the car.
Doctor model test asu January 2026. Next.
Item 15.
Item 15 is triple murder case. Any
Eyewitnesses only.
Yes.
Yes, yes.
January 26. Next.
Item 16.
May I please Lordship? The custody since 2020 matter. 302 case.
Custody?
2016.
Conduct certificate was called in interim. I may prep next week. Conduct during interim bail was called for. I pray for
Interim bail ଯାଇଥିଲା କି?
ନା.
ଆପଣ
jail
हां
conduct during the in the jail.
अच्छा नहीं नहीं आई विटनेस इधर अछन ना
Yes, yes. PW6 child labor.
PW6 बात ना PW6 टा डॉक्टर
ଆପଣ କୋଉ ମେଟେରିଆଲ କରୁଛନ୍ତି?
ଆଇନା 16 ଟା
ଆଇଟମ ଟା ଦେଖନ୍ତୁ।
Item 16, Jail Criminal Appeal 139, 2024. 16.
PW8.
Wait.
फाइलटा टिके माने देई नाथि खाली पाइथिन नाथि
अच्छा हो ठीक है चल पास ओवर कर दूं नेक्स्ट ऐसे कि जेल आइलैंड जो मैटर तो कहिबे तुम जो मैटर आसी
एटा चौद्वार जेल
It has. File conduct.
हां कितने नंबर आइटम चौद्वार
8 and 6 and 8.
6 and 8.
6 pack here. 6 टा बार करें
Finance.
सर्किल जेल चौद्वार कोई अनम्यूट करंदु
सर नमस्कार सर
हाँ अपन किए
सर सीनियर सुपरिटेंडेंट
अच्छा ये मोचीराम हेम्ब्रम बोली जने कि अछंती कि अपन करो ये रे
मोचीराम हेम्ब्रम सर हमर एठी थिला 22/12/2017 सर एठू ट्रांसफर है कि जाजपुर जेल डोमेस्टिक ग्राउंड रे सर पळे छी जाजपुर जेल रोड आज्ञा
अच्छा जाजपुर कोठी जाजपुर
रोड सर सब जेल
जाजपुर रोड जेल
सर
अच्छा ये कौन तो से जाजपुर रोड जेल हम पास ओवर पर
8 नंबर
एटा 6 नंबर गला एटा जाजपुर रोड पुर लगान तापर नेक्स्ट और का केते नंबर बोलबे 8 नंबर नंबर टा होची बिजनेस पर्सन देखा नहीं से जेल लो 50 लेवल को प्रॉब्लम
गोविंद
सरप्राइज जगह एटा 8 नंबर टा होची अगुरु आलियास गोविंद महंत
सर ये अच्छी सर हम जेल वर्तमान
अच्छा और केते वर्ष हेलानी से हां
सर संध्या आइछि त सर
2011 मसिया रोइलानी 18/7/2011 କାଢିଲେ ସେ ଦେଖନ୍ତୁ।
ସାର୍ 9/12/14 ରୁ ସେ ସଜା ହେଇଥାଏ 9/12/14
9/12/14 ଯେ ମାନେ ଇଏ ଦେଖଉଛି 18/7/2011 କୋର୍ଟ ଚାଲାଣ ହେଲା ଆଉ ରେକର୍ଡ ଦେଖଉଛି ସେ ବେଲରେ ଯାଇନି, ସବୁବେଳେ ଥିଲା। ତେଣୁ ଆପଣଙ୍କର
ସାର୍ ପ୍ରିମାଚର ରିଲିଜ ପାଇଁ ଯାଇଛି ସାର୍ ପ୍ରପୋଜାଲ
ଯାଇଛି
ସାର୍
କେବେ ଯାଇଛି?
ତ ସେଟା ଡିଟେଲଟା ସାର୍
କହିପାରିବେ କି ଡେଟ୍ କେବେ ଯାଇଛି ପ୍ରିମାଚୁର ରିଲିଜ ପାଇଁ?
ସାର୍
କଣ ଏଇଟା ଆଲିଗେସନ କଣ 8 ନମ୍ବର? ସେ ଲୋକ ଅଛି କି ଡାକିବେ?
ହଁ ସାର୍ ଡକଉଛନ୍ତି
ତା ସ୍ତ୍ରୀ ସବିତା ମହନ୍ତକୁ ମର୍ଡର କରିଥିଲା। Years child.
ବେଶୀରେ ଅଛି ବର୍ତ୍ତମାନ ଦୌଡ଼ିକି ଆସୁ
ପାଇଲେ ଡେଟ୍ ପାଇଲେ
ମଗେଇ ସାର୍
ଯୋଉ ଆପଣ କହୁଛନ୍ତି ପ୍ରିମ୍ୟାଚୁର ରିଲିଜ ପାଇଁ ଯାଇଛି ବୋଲି, ସେଇଟା ଯାଇଛି ତ?
ହଁ ସାର୍ ଯାଇଛି।
ତାର ଫାଇଲ ଅଲଗା ଥିବ ନା, ପ୍ରିମ୍ୟାଚୁର ରିଲିଜ ପାଇଁ ଯୋଉମାନଙ୍କର ଯାଇଛି ତାର ଅଲଗା ଥିବ। କେବେ ଯାଇଛି
ରିକମେଣ୍ଡେସନ ଫାଇଲ ଥିବ ଦେଖନ୍ତୁ
ସାର୍ ଅଛି।
ଏଟା circumstantial evidence case। ତା ୱାଇଫ ଇଏ ଆଉ ସେ ଛୋଟ ଛୁଆଟା ରହୁଥିଲେ। ଛୋଟ ଛୁଆର ଏଜ ହଉଛି 3 ବର୍ଷ। ଆଉ ଡେଡ୍ ବଡି ମିଳିଲା and he could not explain that। He खाली explain करला जे in my absence somebody had killed her, but he was unable to say who was the assailant। ତାପରେ ଆଉ ଗୋଟେ ପ୍ଲି ନେଇଛି ଯେ deceased sustained fatal injury by dashing against the tube well and died। जो divergent plea नेଇଛି, that was the reason why he was being lacerated wound ଗୋଟେ ଥିଲା right frontal region, ଆଉ ଗୋଟେ ଅଛି right mandible fracture of some। ତାକୁ ଡକାନ୍ତୁ, ଆମେ 10 ମିନିଟ୍ ପରେ ଚେକଅପ୍ କରୁଛୁ ହେଲା। ନେକ୍ସଟ ଆଇଟମ୍
Item 17.
Madam, you are there, you remain there. We take up the matter after 10 minutes।
नहीं present customer।
17 ना?
Yes।
हाँ।
In this case, initial FIR was lodged on 307. After getting treatment, the deceased came to his house and 5 days thereafter he died. The person was arrested on 26 and 21. This honorable court granted bail on 22/8/22।
ट्रायल बेले बेल रे थिले।
Yes।
आई विटनेस अछन।
Yes, only eyewitness madam।
की
6 madam, that
6 डॉक्टर
10।
10 eyewitness को आसिले PW
Doctor is 10, madam.
हाँ
Doctor is
हाँ
10.
4 आगे 6 को आसन
Child witness.
Child witness, madam.
14 witness number okay पढ़ो paragraph number 2-3 पढ़ो
The occurrence for which I am deposing today take place on 24/1/21. That was a Sunday of the week. At about 3 p.m. of that day, my grandfather returned to our house after paying electricity dues. Accused went and assaulted my grandfather with a bamboo stick at his head. I was alone at our house at that time. I have seen that occurrence in my own eyes. My grandmother was absent in her house and as she went to take bath to nearby pond. My grandfather fell down under bleeding condition. I went and narrated the incident to my sister Maya Murmu and my brother-in-law Guruga Murmu. Then we took my grandfather to Kunta Hospital. Then he was shifted to Bible Hospital. Again he was shifted to Kotak Hospital for better treatment. My grandfather stayed at hospital for 22 days. Then we brought him to our house. My grandfather died after 6 days of our house. Police examined me after lodging of FIR. Then my cross-examination. My father had 3 brothers, each of them lives separately. My grandfather and grandmother were.
ଗୋଟେ ଲାଇନ୍ ଟା ପଢୁନା କଣ ଅପିଲ ଶୁଣୁଛୁ ନା କଣ କୋଉ ଲାଇନ୍ ପଢୁ କୁହନ୍ତୁ ଏଣ୍ଟାୟାର ଏଭିଡେନ୍ସ କଣ ପ୍ରେସ୍ କରୁଛନ୍ତି
But that paragraph 7, my lord. When the occurrence took place, I was standing near a tree close to our house. I saw the accused while I was near the tree. I unable to recollect whether accused is in bare body or wearing in any shirt or not. The spot mark doesn't show any presence of any tree matter. My grandfather went to Bholagadia to give electricity bill. Bholagadia is about 10-12 kilometers from the village. But that occurrence is a Sunday matter.
accused ହଉଛି elder brother of my father ମାନେ ବଡ ବାପା ମାନେ he has killed his brother ମାନେ father.
Yes. No. Accused ଆଉ deceased ଦି ଭାଇ ଇଏ ହଉଛି grand daughter.
ନାଇଁ ତୋର କହୁଛି accused standing dog is my ବଡ ବାପା ବଡ ବାପା ମାନେ ସେ କହୁନି ନା elder brother of my father.
Elder brother of my father.
ହଁ ହେଲାନି ତାପରେ ତାର ଯିଏ ମଲା ସିଏ ହଉଛି grandfather. So obviously ମାନେ ବାପାଙ୍କର ବାପା ମରିଛି ବା ବଡ ବାପାଙ୍କର ବାପା ମରା ହେଇଛି ଆଉ ଦି ଭାଇ କଣ
ଭୁଲ କରୁଛି
କିଏ ଭୁଲ କହୁଛି
they are brothers. Appellant and deceased 2 brothers. मतलब
କିଏ ଭୁଲ କହୁଛି ନା ତମେ ଭୁଲ ପଢିଛ grandfather ସବୁଠି କହୁଛି ଆଉ ଭୁଲ କଣ କହୁଛି
informant is my grandmother and the grandmother is saying
grandmother informant was my husband. This is my husband. Maya Hansda is the wife of deceased Gopal Hansda.
तो कौन असुविधा
grandmother.
Gopal Hansda was my grandfather. When the occurrence took place, I went to our house and took note of time occurrence 2 o'clock.
That means you killed your father. That is the evidence, and suggestion was given. Landed disputes were there, and
Para 8, last line. If you read, it will be clear.
Yes, my
there was no landed dispute between my father, his brothers, and grandfather. That means you killed your.
Nobody saying about the landed dispute.
No.
They were in
relationship. Factual aspect रे गंडगोल करिवेनी से बुढ़ाटा कोन ପାଇଁ ଇ कले he was 65 years as it appears.
One is saying it's 8 years.
And what about the doctor? PW10.
Yes.
Fracture of the occipital region.
Laceration injury.
Cause of death was due to head injury.
That after getting treatment, discharged from hospital. After 6 days of the staying in the house, he died.
His statement was recorded.
Yes, no. Police is saying I didn't record any statement, neither of the doctors, 3 doctors or the deceased man.
Deceased.
ଘଟଣା ହେଲା 24 ତାରିଖରେ
Yes,
ଏତଲା ଦିଆହେଇଛି 25 ତାରିଖ ତା ନେକ୍ସଟ ଦିନ
yes, ma'am.
307 ର କେସ୍ ହେଇଛି
Yes.
2 ଜଣଙ୍କ ନାଁରେ ରହିଛି ଏତଲା ଗୋଟେ ହଉଛି ପନ୍ନା ହଣ୍ଡ୍ରେସ୍ ଆଉ ଗୋଟେ କୁଲ ହେନ୍ଦ୍ରେସ୍
She's my daughter.
ମାନେ ଇଏ ସ୍ୱାମୀ ସ୍ତ୍ରୀଙ୍କ ନାଁରେ ହେଇଛି ଏତଲା
नहीं, ये स्वामी स्त्री नहीं,
ବାପା ଝିଅ
झियो.
ଆଚ୍ଛା ବାପ ଝିଅଙ୍କ ନାଁରେ ଅଲରାଇଟ୍ ତାପରେ
26 ତାରିଖରେ ଡେଥ୍
ଡେଟ୍ କେବେ ହେଲା
26/2
26 26 ପୁରା ମାସେ ତ ଅଛି
Why the statement was not recorded?
I always my daughter.
ସଂକଟାପନ୍ନ ଅଛନ୍ତି ବର୍ତ୍ତମାନ ଆମେ ଜଣଛୁ you can continuously under treatment first ପ୍ରଥମେ ନେଲେ ଖୁଣ୍ଟ ଗୋଷ୍ଠୀ ସ୍ୱାସ୍ଥ୍ୟ କେନ୍ଦ୍ରକୁ ସେଥିରୁ ନେଲେ ଜିଲ୍ଲା ମୁଖ୍ୟ ଚିକିତ୍ସାଳୟକୁ ତାପରେ ସେଠି ସଂଗ୍ରାମ କରୁଛି ତାପରେ ବୋଧେ ଅନ୍ୟ ହସ୍ପିଟାଲକୁ ଶିଫ୍ଟ ହେଇଛି ନା ସେଇଠି ମରିଗଲା
ଆୟୁ କିଏ
ଏସସିବି
I would take my daughter PW30. He has also got information that the disease is getting treatment in the SCV on 5/2/20.
No, any question has been put that why the statement was not recorded of that deceased.
Paragraph 16, page 74. To my knowledge, the deceased got treatment at least in 3 hospitals. I didn't examine the doctors who gave treatment to the deceased Baripada and Kotak. I didn't move to Kotak to cross-verify the medical documents as produced by the unanswer. I can't say the date on which the deceased was admitted and discharged from hospital at Kotak. I didn't keep any track of the treatment of the deceased Kotak. I didn't examine the victim at any time at his village after he was brought from Kotak hospital.
And para 5 he has said its the health condition was critical, therefore I could not examine. Para 5 of this.
Yes, at the time
I came to know that the injured was shifted to so and so hospital. I found the health condition of the victim was critical. I was unable to examine him due to health condition.
At the time of Khunta, first initial stage. But see, he got information on 5/2/20. The victim,
ମାସ ପରେ ଡେଥ୍ ହେଇଛି ତ ଏ ଗୋଟେ ଭିଜିଟ୍ କୁ ଗଲା ମାନେ
ତାପରେ ଆଉ ଯାଇନି
ବାରିପଦା ପରେ ଆଉ ଯାଇନି ସେ କାରଣ ପ୍ରଥମେ ଆସିଲା ଖୁଣ୍ଟାରୁ ଗଲା ବୋଧେ ବାରିପଦାକୁ ବାରିପଦାରୁ ବୋଧେ କଟକକୁ ଯାଇଛି
that stick was recovered without any blood stain.
When the death took place, Mr.
26 Page 2 judgment last 3
You were on bail during trial.
Yes. This honorable court granted bail on 28/22.
The bail was rejected by this court anytime.
No. Allowed.
ये केस में bail आगू reject ही नहीं
No.
देखिए
Single blow.
Criminal antecedent किसी अच्छी
Single blow please.
Jail conduct
এটা আছে conduct jail conduct is available. Jail conduct is available.
कौन अच्छी
No adverse. There is no adverse report.
don't have are the learned counsel for the petitioner, learned counsel for the state. As per the order dated 29/2025, the learned counsel for the state has produced the written instruction received from Senior Superintendent, Circle Jail Baripada. It shows that the conduct and behavior of the petitioner towards the co-inmates and the staff is normal, and there is no adverse report against him. The report is taken and record stock. Learned counsel for the petitioner submitted that the petitioner was taken into judicial custody in connection with this case on 26/1/2021, and he was granted bail by this court during trial. And after the pronouncement of the judgment on 29/8/2024, he has been again taken into judicial custody. The land council.
No sleep.
Honda?
No
No sleep.
international.
Court file.
That is Saraj.
Court file.
That was 184.
184. Huh? 184 तो केस डायरी ना
Was a case there.
कौन लिखा है जी
22/5/21 date.
22/5/2021 verification of the CA of the so and so no criminal land counsel for the petitioner also pointed out from the records that the petitioner is having no criminal antecedent. He submits that the occurrence in question took place on 24/10/2021, 24/1/2021. The report was lost, FIR was lost on 25/2021 under section 307/34 of the Indian Penal Code against the petitioner and his daughter. And charge sheet was submitted only against the petitioner. The deceased died on 26/2/2021, which is more than a month after the occurrence. And though the case is based on the solitary testimony of eyewitness PW6, who is a child witness, but the IO has not offered IO bracket PW 13 has not stated anything as to why he did not take any steps for recording the dying declaration of the deceased while he was undergoing treatment in SCB Medical College Hospital. Even though he came to know about the shifting of the deceased to SCB Medical College Hospital on 5/2/2021. Land Council submits that there are good chances of success in the appeal and balance of convenience is in his favor. There is no likelihood of the appeal being taken up early for hearing. Therefore, their application may be favorably considered. Land Council for the state, on the other hand, place the evidence of eyewitness bracket rank PW6, which shows that the petitioner is related to the deceased. He also placed the evidence of the doctor bracket PW10, who conducted post-mortem examination and noticed injury on the head and opined that the cause of death was due to head injury and shock. Considering the submission made by the Land Council for the respective parties, evidence available on record, fact that the petitioner was on bail during trial, and absence of any material that he has misutilized the liberty while on bail during trial, absence of any criminal antecedent against him, and also the jail conduct report as produced by the Land Council for the state. We are in signed review of the petitioner on bail. Yes.
16 file this. Item 16 file ta nathila.
16. Yes.
ଆପଣଙ୍କର ସିନ୍ଧୁ ନା କଣ ପ୍ରିଜନ ନାହିଁ କି?
Contradiction 26/10/2020 matter.
ଶିବେନ୍ଦ୍ର ସିଂହ ତମେ ଉପରକୁ ଆସ।
Yes.
PW 8 is the item.
Very matter.
Just a minute.
PW 8.
The father killed son.
PW 8 is the eyewitness. Our doctor came.
Doctor PW 6.
I was 12.
ତମେ ଟିକେ ଉପରକୁ ଆସ।
PW 6 को आसो। PW 8 eyewitness. Pardon.
The incidents took place about 3 years back in the night hour. I was sleeping with the deceased in the other room of Sanatana Mahanta. My daughter had gone to her aunt's house with her daughter. The accused came and took the deceased and a small thing on a stone, for which the deceased sustained injury on his head and died. The deceased was around 2 years at that time. I was examined me in this case.
Yeah, what is the acha? Samane accused is my acha father killed the
His son.
And she is the mother.
Is the mother-in-law of the accused.
Mother is the accused and
who is my acha ये तमने होची माने सासू आ रहा है अच्छा
the motive होचन कि जे
smashed him on a stone for his deceased
2 years ago ना तेरा 5 years
ये 2 years
5 years
शुभेंदु सिंधु की सिंधु जी ଅଛି शुभेंदु
evidence of the doctor is PW 6
କିଛି ସମୟରେ କଟକରୁ ବାହାରୁଛନ୍ତି କେବେ ଆମର ବି ଦେଖୁଥିଲେ ସିଏ କମନ ବର୍ଗନ ସିଂହ ମାନେ ଭଉଣୀ ଆସୁଛନ୍ତି ଦେଖା ତାକୁ ଉଠିବା ପରେ ତୁ ରାଇଟ୍ ଅଫ୍ ସିରିଆ ରାଇଟ୍ ଅଫ୍ ରେ ଏବେ ନାହିଁ ତାକୁ ଲାଠି କରିବି ଖବର ଦେଖାନ୍ତି ଏବଂ ବି ଖବର ଦେଇକି ଗ୍ରେଡ୍ ସେଣ୍ଟ୍ରି ପକଉଛି ସିଂହ ବି ଆସିଲେ ସାଙ୍ଗେ ସାଙ୍ଗେ
What was the motive? Only motive when the accused came to house, searched his wife, found the wife absent, killed. He is psycho.
The appellant's wife and daughter came to his in-laws house, and there
what is the present status of that witness, that lady who had deposed the sasuro or strira on ghare jibo
He has not been examined.
Stree is not eyewitness. He was not present.
Just ascertain what is now the present status of the wife of the who has not been examined as a witness, and also this lady who has deposed against this man. ये बुढ़ी की सेतेबेले 65 वर्ष ହେଇଥିଲା
70
तो वर्तमान the Land Council for the state seeks some time to obtain instruction regarding the status of PW 8 Suku Mani Behuri, the sole eyewitness to the occurrence, who is also the mother-in-law of the petitioner, and also that of the wife of the petitioner. Instructions are also be taken about
Wife of petitioner ना किसी नहीं माने record रे
ऐसे पहुंची कि नहीं
and she received the compensation.
Just take instruction number.
Sure. She has examined in by the police, but not in the trial.
So and also the criminal antecedent, if any, against the petitioner is jail conduct. Matter prepares to be commencing from 27th October of that same.
The jail authority is ready.
अच्छा
Another case, my lord, special notice. special have over phone the IAC intimated that he arrived at the spot, got information that the father of the applicant died. But written they say must 15 kilometer
Day
distance
after
Kali.
tomorrow, day after tomorrow. Yeah. This, this matter was not in the list. On being mentioned in the first hour that the father of the appellant has expired on Quebec. 9/10/2025. We directed the matter to the state. And accordingly, the matter has been listed. Special mention. The Land Council for the state was also asked to obtain instruction regarding the death of the father of the appellant. So, Land Council for the state submitted that after receiving the instruction, the IIC of the concerned police station, Sergod police station,
over phone intimate
has been to this has intimated about the death of the father, but the matter may be taken up day after tomorrow, so that the concrete information regarding in writing will be obtained from the concerned IAS. Put up this matter on 15th of October 2025. अपन तो 6 दिन है तो 6-7 दिन ठीक है. हाँ अच्छी फोन हाला कुछ आसी लगी.
हाँ सर नमस्कार.
मैटर चे जे फोन.
हाँ 6 item
6 नहीं 8.
सर नमस्कार.
एकटा बात है.
विभिन्न amount of
ये डेट टा मिलिला कि केबे तार प्रीमैच्योर रिलीज पाई.
सर नमस्कार. सर तार जाइछि 1/9/25 रे सर जाइछि.
अच्छा 1/9/2025.
सर डायरेक्टरेट.
फाइनल फॉर्म टा देखो.
1/9 सर. सर एडी कन्विक्ट अछि ए गोविंद. एडी सर कन्विक्ट है.
ये तार जो ये डेट दिया है 18/7/2011.
हाँ सर सर अंडर ट्रायल पीरियड सर.
सेट अंडर ट्रायल रु थिला तो.
सर 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 से जाजपुर जेल रु ट्रांसफर होई के हम जेल को आछि 25/12/14 रे सर हम जेल को आछि.
नहीं ता ये भीतर से बेल रे पड़ जाइनी इंटरिम बेल अन्य किसी जाइनी.
ना सर बेल फेल जाइनी कोर्ट से नीचे कोर्ट बेल जाइनी कि छुट्टी भी जाइनी बिन फॉलो पैरोल छुट्टी भी जाइनी.
अच्छा
सर
से छोट छुआटा जो सेटा 3 वर्षर थिला से का पाखे अछि एगा. पचारतु तार गोटे छोट छुआ थिला 3 वर्षर.
सर सर भाई मान पारे अछि बोली कहूछ घरे अछि.
केमती जेल कंडक्ट केमती अछि.
सर जेल कंडक्ट गुड अछि. हम नाम सर ठीक ठाक पहुंचे.
घरे आउ कि अछंती तो.
घरे आउ कि अछि. सर बापा मां अछन बोली कहूछ.
ये सर्कमस्टेंशियल एविडेंस.
concentration पे जाइए premature सर.
This case number 1 of 2017, there is an application for bail. You are Mr. Chaudhary? Yes,
Sujit
Kanan
Kumar
Bala.
Raul.
हाँ
Sir, Sujit Kumar Raul.
नहीं नहीं मैं काउंसिल को ना पूछो मिस कानन बाला रॉय चौधरी the land counsel for the petitioner is speaking. The appearance of the appellant through virtual mode was ensured and the ଆପଣଙ୍କ ନାଁ କଣ?
Sir, Sujit Kumar Raul.
Sudeep Kumar Raul. ROUL.
Sir,
What is your designation?
The senior superintendent.
Senior superintendent, Circle Jail, Chaudhar.
Sir.
Is it Raul or Raut?
No, sir, Raul. RAULA.
ROULA is present. It appears that the land counsel for the petitioner submits that the petitioner was taken into judicial custody on 18/7/2011 and he was neither released on bail during trial and he has also not been released during pendency of the appeal and as such he has remained in custody for more than 14 years. Stop. She further argued that the case is based on circumstantial evidence and the allegation against the petitioner is that he's killed his wife Shabita Mohanto. Land counsel for the petitioner further argued that since paper book has not been prepared and there is no chance of early hearing, therefore the bail application may be favorably considered. Peruse the impugned judgment and the evidence on record. The jail superintendent stated that the conduct of the accused in jail is good. And the recommendation for his premature release has been made on 1/9/2025, which is pending with the government. He further submits after ascertaining from the petitioner that the child of the petitioner is now being taken care of by the कार के भाई मानक पाखे छुआ छी ना का पाखे से कहूँ
हाँ सर भाई मान पर अछि
by the brothers of the petitioner and घरे की रोजी खाली माँ
सर घरे तर बापा माँ अछंती
and the old parents of the petitioner are staying in the house. Considering the submission made by the land counsel for the state opposed the prayer for bail, however, doesn't dispute that the case is based on circumstantial evidence. Considering the submission made by the land counsel for the respective parties and the nature of evidence available on record and the period of detention of the petitioner in judicial custody for more than 14 years, absence of any chance of early hearing of the appeal in the near future, and taking into account the jail conduct as stated by the senior superintendent, we are inclined to release the petitioner on bail. बाकी usual terms and conditions. तर बेल हे गला ताको कहबे बेल बंद कर दे जीवो गंडगोल किछ करिवनी
सर सर
କୋଉ ଜେଲ
ଝାରପଡ଼ା ଜେଲ ଥିବ।
କେତେ ନମ୍ବର ଆଇଟମ?
ଆପଣ କୋଉ ଜେଲର? ଅନମ୍ୟୁଟ କରନ୍ତୁ। ଅନମ୍ୟୁଟ।
କେତେ ନମ୍ବର ଆଇଟମ?
ଅନମ୍ୟୁଟ କରନ୍ତୁ।
ସାର୍ ନମସ୍କାର।
ଆପଣ କୋଉ ଜେଲରୁ?
ସାର୍ ଭୁବନେଶ୍ୱର ଝାରପଡ଼ା।
କୋଉ ନମ୍ବର ଆଇଟମ ରେ ଡକା?
4/15 ଆଇଟମ 4
ନା କଣ ସେ ଆପ୍ଲାଣ୍ଟ ର?
ବାଙ୍କନିଧି ନାୟକ।
ବାଙ୍କନିଧି ନାୟକ ଆପଣଙ୍କ ଜେଲରେ ଅଛି?
ସାର୍ ସେ ଏକ୍ସପାୟାର କରିଯାଇଛି 10/2/2020 ରୁ ସାର୍।
ଆପଣ ତା ପାଇଁ ବେଲ ମୁଭ କରି ଆପିଲ ରେଡି ହେବେ। ଆପଣ କହୁଛି ନା ମୁଁ ମେରିଟରେ ରେଡି ମରିସାରିଲାଣି। କେବେଠୁ ମଲା?
ସାର୍ 10/2/2020।
କଣ ଡକୁମେଣ୍ଟ ଅଛି? ଜେଲରେ ଥିଲାବେଳେ ମରିଗଲା?
ନାଇଁ ସାର୍ କ୍ୟାପିଟାଲ ହସ୍ପିଟାଲରେ ଟ୍ରିଟମେଣ୍ଟ ହଉଥିଲା
ହଁ ସେଇ ଜେଲରୁ ଯାଇଥିଲା
ସାର୍।
କ୍ୟାପିଟାଲ ହସ୍ପିଟାଲକୁ, ସେଇଠି ଏକ୍ସପାୟାର କଲା ତ?
ସାର୍ ଆଜ୍ଞା
ସେ ଡକୁମେଣ୍ଟଟା ଟିକେ ପଠାନ୍ତୁ।
ସାର୍
ଜେଲର ଏଣ୍ଟ୍ରି ବର୍ତ୍ତମାନ
WhatsApp
ରେ ପଠେଇ ଦିଅନ୍ତୁ ଯାହା ଡକୁମେଣ୍ଟ ଅଛି ରିଗାର୍ଡିଂ ହିଜ ଡେଥ।
ସାର୍
ବାଙ୍କନିଧି ନାୟକ, ବାପା ନା ହଉଛି ଲେଟ୍ ଭାସ୍କର ନାୟକ,
ନାୟକ,
ଭିଲେଜ ହଉଛି କଣ ପାଇକ ରାୟପୁର,
ଚନ୍ଦକା,
PS ଚନ୍ଦକା, ଡିଷ୍ଟ ଖୋର୍ଦ୍ଧା, ଠିକ ତ?
ସାର୍
ହଁ ଡକୁମେଣ୍ଟଟା ପଠାନ୍ତୁ ଲେଖନ୍ତୁ।
ସାର୍
Mr. Vijay Kumar Robert, Land Council, is present. ଆପଣଙ୍କର ନାଁଟା ଟିକେ କୁହନ୍ତୁ।
ସର୍ବେଶ୍ୱର ସାହୁ।
ସର୍ବେଶ୍ୱର ସାହୁ, ଆପଣଙ୍କର କଣ ଡେଜିଗ୍ନେସନ?
ସୁପରିଟେଣ୍ଡେଣ୍ଟ।
ସୁପରିଟେଣ୍ଡେଣ୍ଟ ଝାରପଡ଼ା ଜେଲ?
ଆଜ୍ଞା ସ୍ପେଶାଲ ଜେଲ ଭୁବନେଶ୍ୱର।
ଝାରପଡ଼ା ନାଇଁ ଝାରପଡ଼ା
ସ୍ପେଶାଲ ଜେଲ ଭୁବନେଶ୍ୱର।
ସ୍ପେଶାଲ ଜେଲ
ଭୁବନେଶ୍ୱର
ଝାରପଡ଼ା. Appearing through virtual mode submits that the appellant while in jail fell ill and he was taken to Capital Hospital. Capital Hospital, and during course of treatment he expired on Kebe 10/2/2020. ऐसे कोविड फोविड रे गलानी तो ना कौन
सब फाइल देखिनी सर देखी सर।
अच्छा हो अपन वर्तमान साइंस है पठेई देबे तो?
हां सर पठेई दो साइंस सर।
The Land Council he has sent the relevant documents regarding the death of the appellant to the Land Council for the state, which is produced before us and taken on record. In view of the death of the appellant, the jail criminal appeal abates and according to disposed of. ଆଣିକି ଦିଅ ଠିକ ଅଛି। ତାପରେ ଅନ୍ୟ ମ୍ୟାଟର ଗୁଡା ଯୋଉଟା ପାସ୍ ଓଭର ହେଇଥିଲା ନାଇଁ 5 ନମ୍ବରଟା ଆଉ କିଏ ଅଛନ୍ତି କି ଦେଖିଲେ? ଆପଣ ସେ ଯୋଉ ମ୍ୟାଟର ଗୁଡାକ କୁହାଇଥିଲା ସବୁ ଆଣିବାକୁ ଇନଫର୍ମେସନ, ଯୋଉ କାହାର ଡେଥ ହେଇଛି, କିଏ ପ୍ରିମ୍ୟାଚୁର ରିଲିଜ ହେଇଛି, ଏଗୁଡା ସବୁ ଆଣିଲେନି। ये जो मैटर मन कर आज आम डायरेक्शन दे था या पेपर बुक तैयारी होगा सी आर्गुमेंट करते गोटे जजमेंट लिखाई था केते समय जाता कोर्ट रो। तो 5 आउ 7 रे इंफॉर्मेशन दे तो। अच्छा नेक्स्ट आइटम देखो।
Item 18.
Since 2019.
ये तो फाइनल फोन बात है। Judgment. You are the husband of him?
Yes. Husband, but this much.
Deceased, who is the deceased? ତା ନାଁ ହଉଛି କଣ?
ଶୋଭାବତୀ ସାହୁ ଆଲିଆ
ଶୋଭାବତୀ। ଆଜ୍ଞା। କଣ ମେଟେରିଆଲ କଣ ଅଛି?
ଆଇ ୱିଟନେସ୍ PW 15
ଓ ଆଇ ୱିଟନେସ୍ ଅଛି।
ସନ୍
PW କେତେ?
15
ମାଇନର ସନ୍।
PW 11 is the doctor.
PW 11
ଆଜ୍ଞା।
ପଢିଲେ 15 ସାକ୍ଷୀ ପଳେଇ ଆସନ୍ତି। 10 ବର୍ଷ ତାର ଥିଲା। କ୍ଲାସ 5 ରେ ପଢୁଥିଲା ଗଭର୍ଣ୍ଣମେଣ୍ଟ ୟୁପି ସ୍କୁଲ।
5 ବର୍ଷ ଥିଲା ଡେଟ୍ ଅଫ୍ ଅକରେନ୍ସ page 120 my lord.
ଆପଣ
The informer is my mother, sister, husband, Mausa. The accused is my father. The deceased was my mother. She died in the rented house at Jagannath Prasad, where I, my father, and my mother, and my younger brother were residing. At the relevant time of occurrence, I was 5 years old. The occurrence took place in between 7 to 8 a.m. My father was used to assault my mother regularly. On the relevant day, my mother was spreading wet clothes in order to dry up in front of our rented house in a row. My father came and gave a tangier blow on her head, and then my mother took a towel and placed it there at the place of wound. And she was trying to go away. Then my father again gave a tangier blow on her head. When she fell down and shivering, the deceased again gave a blow on her head.
କେତେଟା ବ୍ଲୋ ଦି?
ତିନିଟା ବ୍ଲୋ। ସେ ଦୌଡ଼ିଲା ବେଳେ ପୁଣି ଆଉ ଗୋଟେ ପୁଣି ଯେତେବେଳେ
ଏଇଟା ଥାଉଥିବ ଜାନୁଆରୀ ରଖିଛନ୍ତି। January 2026. In the meantime, ଲେଖିଦିଅନ୍ତୁ ଦିଲାଣି। ଇଏ ପଢୁଥିବ ତ ଏଇଟା ଜାନୁଆରୀ 24 ଦେଇଛି ଆଉ। 24 ମାନେ ସେ ବର୍ତ୍ତମାନ ଏଇ କ୍ଲାସ 6 ହବ ତାର। କାରଣ 2024 ଡିପୋଜିସନ ଦେଇଛି। ସେତେବେଳେ କ୍ଲାସ 5 ରେ ପଢୁଥିଲା ଆଉ 6 ରେ ପଢୁଥିବ ଆଉ ଦେଖାନ ଖାଲି ଜାନୁଆରୀ 26 ରଖିଦିଅନ୍ତୁ। ତା ନେକ୍ସଟ
Item 19.
Mother-in-law.
କଣ ହେଇଛି?
302 IPC. And
mother-in-law.
my lord.
କିଏ mother-in-law? କିଏ mother-in-law?
Appellant is the
498
Oh, 498 is.
490 is the he acquitted from the charge under
302
and section 4 of the DPR. Our convicted under section only 302.
Chandini Mohanta.
Chandini Mohanta. Her both her this appellant and her husband, they tried to rescue the victim, but the victim, her husband also sustained injuries.
What type of injury?
Her husband died of
injury.
And
cause of death कौन?
ये cause of death is due to burn injury.
ये dying declaration.
Dying declaration recorded that is for case वाला the exhibit P5.
Oral dying declaration as well as the dying declaration.
Oral dying declaration before the
नहीं ये doctor
मतलब PW 15.
नहीं जो dying declaration record की कोई
11
PW 11 बार medical officer.
Medical officer.
I treated so and so recorded his statement on police requisition. Dying declaration exhibit P5. पाँच पढ़ନ୍ତୁ dying declaration ମୁଁ ମୋର
ସାଙ୍ଗ ସହିତ ଫୋନ
page number 99
କଥା ହେଲା ବେଳେ ମତେ ଗାଳି କଲେ।
ମୁଁ ମୋ ସାଙ୍ଗ ସହ ଫୋନରେ କଥା ହେଲା ବେଳେ ମୋର ଶ୍ୱଶୁର ମତେ ଗାଳି କଲେ ଆଉ କହିଲେ ବହୁତ ଦେଖେଇ ଦଉଛୁ। ମୋର ଶାଶୁକୁ ଡାକିଲେ ଆଉ କହିଲେ କିରୋସିନ ଆଣେ ଆକୁ ଆଜି ପୋଡିଦବା। ତାପରେ ମୋର ଶାଶୁ ଆଉ ଶ୍ୱଶୁର ଦୁହେଁ ମିଶି ମୋର ଦୁଇ ଗୋଡକୁ ବାନ୍ଧି ଦେଲେ ଆଉ ଇଟାରେ ମୋ ମୁଣ୍ଡ ଆଉ ମୁହଁକୁ ପିଟିଲେ। ତାପରେ ଶାଶୁ ଆଣି କିରୋସିନ ଦେଲେ ଆଉ ଶ୍ୱଶୁର କିରୋସିନ ଢାଳି ନିଆଁ ଲଗେଇଦେଲେ ଆଉ ଘରେ ମତେ ଘର ଭିତରେ ଛାଡି ବାହାରୁ କବାଟ ଦେଇ ପଳେଇଲେ। ମୁଁ ଦୌଡ଼ି କାଢି ପେଜକୁ ମୋ ଉପରେ ଢାଳି ନିଆଁ ଲଗେଇବା ପାଇଁ ଚେଷ୍ଟା କଲି ତାପରେ
ନିଆଁ
ଘରେ ହିଁ
ଲିଭେଇବା
ଥିଲି।
ପାଇଁ ପେଜକୁ ମୋ ଉପରେ ଢାଳି ନିଆଁ ଲିଭେଇବା ପାଇଁ ଚେଷ୍ଟା କଲି।
ତାପରେ ଘରେ ହିଁ ଥିଲି କଷ୍ଟରେ ପୁଲିସ ଆସି କବାଟ ଖୋଲିଲେ ଆଉ ମୋତେ 108 ଏଠାକୁ ଆଣି ବ୍ୟବସ୍ଥା କଲେ।
କିଏ ତାମାନେ ଶାଶୁ କିରୋସିନ ଦେଲେ ଶ୍ୱଶୁର what about ଶ୍ୱଶୁର?
ଶ୍ୱଶୁର he sustained injury, he died in the during treatment.
Acha. So this is the evidence of ये रहिला अपन एटा ला exhibit 85 ଆଉ डॉक्टर एविडेंस ला केते PW 11 ହେଲା डॉक्टर बाकी oral dying declaration
5 and 6 fire officer
PW 5 and PW 6 fire officer ଦି ଜଣ ଯାକ
fire staff sir
ହଁ ପଢିଲେ PW 5 ନାଇଁ ତ PW 5 fire officer ନୁ ହଁ fire ପଢନ୍ତୁ
I do not know the informant. I know the deceased Manasi Mahanta. I know the accused Chandani Mahanta. The mother-in-law of the deceased. The occurrence took place on 4/2/2021 in between 7:30 to 8 p.m. On the day on received a telephonic message at the Jumpura fire station from Palasanga police outpost. We proceeded to village Deudi. I found a palagada burning and smoke blowing from a house. We extinguished the fire in the palagada. We broke open the door of the house from which smoke was coming out. We found the deceased Manasi Mohanta was being completely burned. Blood was oozing out of her head and face. On being asked about the cause, the victim told us that her husband is in jail in a rape case and that her father-in-law and mother-in-law had subjected her to torture.
After 19, well,
Jail criminal appeal we don't want to reject January 2020. Yes, next.
Item 20 matters. The appellant is in custody since October 2014 millers. He was granted interim bail for 3 months and he surrendered in time. And surrender certificate is a flag. The last occasion time was granted.
Conduct during interval we have to procure and by next week.
Last 3 dates minutes time was
Interdate नहीं चलेंगे.
interdate नहीं चलेंगे.
I prefer next week.
21/7 was the direction. Then 28, then 8/9.
Power पठी जाएगी.
हाँ 21/8 के लेटर 10/9 लेटर. Paper next week only.
IA number 3185/2024. This is an application for bail. Land Council for the state seeks some more time to obtain instruction regarding the conduct of the petitioner while he was on interim bail. 22 तारीख रखुछु.
Okay.
Put up this matter on 22nd. 10/2026. Yes, next.
Item 21.
Yeah, it's simple. I directed the state council to for the conduct of the appellant by order dated 12/5/2023.
Got it?
And as per instruction, the petitioner is
involved in 2 criminal cases.
conduct any of quite
नहीं,
a
ये 22 तारीख का।
22 तारीख 22 frame 20 next
Item 22.
Here is the offense on the
last time the phone
last time that was subsequently I have filed another power. That is signed by the
अरे हमको criminal antecedent और custody certificate has called for. The criminal antecedent report has come, but in the meantime, the convict has transferred to Koraput jail. So ये paper next week I will call. I have already.
ଏଇଟା କଣ ଆଣିଛନ୍ତି
That was a criminal antecedent.
କଣ ଅଛି କେତେ ଅଛି
नहीं, nothing adverse against him except.
ଖାଲି କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଆଣିବେ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଦିଟା ଜାଗାରୁ ଆସିବ
हाँ दो कोरापुट ରୁ ଆସିବ ଆଉ
ମିଶେଇ ଗୋଟେ କରି
ମିଶେଇ ଗୋଟେ
my humble submission is that
ଆପଣ ପାଖରେ ଅଛି ଦଉନାହାନ୍ତି
since he was arrested, he never had gone there.
କି ଜାଣିଲା ସେ ପ୍ରାୟ ସେ
ନାଇଁ।
ପିରିୟଡରେ ସେ
ଗୋଟେ
କୋଭିଡ ପିରିୟଡ କେତେ ଜଣ ପଢାଉଥିଲା
ଏବଂ ସସ୍ପେନ୍ସ
ଆସୁ ଦେଖନ୍ତୁ the learning council for the state has produced the କୋଉଠି ଏଟା conduct certificate କାଇଁ
ସେ ଲେଖିଛନ୍ତି CC10 online module found nothing adverse
Acha.
against him.
Submit that there is no adverse report against the petitioner. However, so far as custody certificate is concerned, since the petitioner is as present lodged in Circle Jail Koraput, na?
Again.
Circle Jail Koraput. Initially se कोड थिला
Raigada.
So he was initially in Raigada jail. The matter may be taken out
22 तारीख
on 22nd to produce the custody certificate. Put of this matter on 22nd is.
Item 23.
On behalf of Mr. CSR. In this case, offense under.
कौन एगुड़ा इत्ते फाइल कर देंगे? दीटा interim bail, गोटे regular bail.
Previously, one
कोटा कोटा not press हो कोई यहाँ तो interim bail उड़ा not press कर दो
one interim bail was not pressed
दीटा प्राची
on 45 of 2018.
IN number list cause list दो ना
One is granted my lord interim previously.
15 days अब कौन dispose of ही नहीं किया और देखे ही ना
One is 45 of 2018.
wait IN number 1219 of 23 that are pending अच्छी bill देखो जिन
23 ର ଗୋଟେ 24 ର ଗୋଟେ ଦିଟା bill
ଆଉ ଗୋଟେ 24 ର ଗୋଟେ ଦେଖौ ଯେନ୍ତି ଦିଟା pending ଅଛି
44 ର ଗୋଟେ ଅଛି
हां
24 ର ଗୋଟେ
हां ଗୋଟେ 23 ର ଅଛି ଏଟା dispose of कर दो
Fine.
देखो IN number 1219 of 2023 and IN number 262 of 2024. These are the two interim bail applications. Land Council for the petitioner doesn't want to praise this interim application. Accordingly, the interim applications are disposed of as not praised. Yes, now IN number 2577 of 2025. So, how many appellants are there?
In this case, 1/5/2025 interim bail was allowed.
Huh?
2 months interim bail was allowed.
Kothre ଯାଇଥିଲା ବେଲ
1/5/2025.
1025.
1080 of
1080
order को order ରେ ଯାଇଥିଲା
1080 2025 my lord I have already surrendered certificate.
और ତା conduct ଟା କଣ ଅଛି ସେଉଟା ମଗେଇବ ନା ଦିଅନ୍ତୁ surrender certificate. IN number so this is an application for release of the petitioner on bail. it appears that the petitioner was granted interim bail for a period of 2 months. है ना? My order detailed 1/5/2025. Land counsel for the petitioner has produced the surrender certificate, which is taken on record. Land counsel for the state seeks an adjournment to obtain instruction regarding the conduct of the petitioner while on interim bail. Because of this matter, we commence 27 तारीख को call. है ना? Yes. 27/10/2025. Next.
Item 24.
Last year, to obtain the mental condition and the elements of the prisoner.
She threw her 3 minor children into the well, for which her 3 children died.
Mental condition.
There is the motive. There is the motive.
The mental condition and
Hey, wrong 19.
it's
कौन आसिला पढ़ंतु?
currently normal. This to inform that the above mentioned patient Shobhagini Behera was brought to the psychiatric OPD for admission on 15/9/2025. The patient was admitted from 15/9/2025 to 17/9/2025. Her detailed psychiatric history was obtained and her mental status examination was done. Patient was also observed in ward for 2 days. Her old medical records were also obtained. Her close relative, her brother Amit Sethi, was also called to obtain her history. From all above assessments, the patient was found currently normal, but we had difficulty to eliciting her past mental health report from her medical file. Her accompanying jail attendant and her brother were unable to give her reliable and adequate history during the time of the alleged trial.
वर्तमान ठीक ठाक अच्छी.
ବର୍ତ୍ତମାନ normal ଅଛି.
Custody since
11/9/2016.
काहींदी. केस कौन ये circumstantial evidence ना eye witness.
Circumstantial.
Evidence of PW 70.
हाँ?
PW 70.
कौन कौजी?
PW 17 my lord.
और ना जी?
My lord.
Is it?
Wait, excuse me.
PW 7. My lord, the informant is the husband of my father's sister. The accused is the wife of his son. The occurrence took place around 3 years back at about 11 a.m. at village Gurjang. At the relevant time, I was staying with the informant and studying at Ambapal High School. It was a Saturday. On that day, I had been to school. The informant and his wife had gone for labor. On my return from my school, I heard shout from the well. I found the accused inside the well and her youngest child was dead inside the well. I called for help. I, along with Saroj, brought the accused from the well. I then called for the informant. The informant brought one dead body from the youngest child from the well. Thereafter, 2 dead bodies of other 2 children of the accused were recovered.
What is your accused statement? deny করছি.
Denied ମୁଁ ଜାଣିନି.
ଏ ତ ଭଲ କଣ୍ଡିସନ ତାମାନେ ଅଛି ଆଉ ବୁଝିକିନି କ୍ୱେଶ୍ଚିନ୍ ପଚାରି ବୁଝୁଛି ଆନ୍ସର ଦଉଛି ମିଥ୍ୟ ଘଟଣା କହୁଛି ମୋ ଶାଶୁ ଶଶୁର ମୋ ନାଁରେ ମିଛ କେସ୍ କରିଛନ୍ତି ସେତେବେଳେ କଣ ଗୋଟେ ଗଣ୍ଡଗୋଳ ହେଇଯାଇଥିଲା ଆଉ
In the cross examination, PW70, para 4 କହିଛି the accused has accused with others, term with others family members. I have never heard the accused threatening to kill or abet. The well is front of the house. The three children were sometimes playing with each other. I hear the shout of the accused, Amaku Bonchao, help us. I cannot say who was involved in this case.
One is 8 months and another is 2.5 years.
Mental stress with you for the children.
ତା ସ୍ୱାମୀ କଣ କରୁଛି?
Swami, husband is the custody. In the meantime, another case.
Custody ମାନେ କଣ ପାଇଁ?
Another NDPS case. In the
problem.
And I also stated in the deposition para 15 last line, I did not recommend the accused for polygraphic test to ascertain the truth.
या घर कोठी येरो ये जो accused
Hello.
दिनेश गुरुजंग पीएस किशन नगर चिस्टा अनबुल एटा अनबुल अछि
Hello. Atman.
हां ताकू ए मझिरे मझिरे दी थर खंडे आनी किनी ताकू प्रोड्यूस करंतु हमर एठी अबिका जेल कंडीशन ठीक अछि हमें देखिलु बट इट मे बी दैट सी जो एटा फूड की प्रोड्यूस हितला ऑनबुल डिस्ट्रिक्ट हेडक्वार्टर्स हॉस्पिटल ले कटक रे प्रोड्यूस करंतु बेटर तार एनालिसिस हे परिबो हां तो दी IIC shall make next IIC no we are directing the superintendent. He has to make arrangement for producing the accused or the petitioner. At least we are granting him bail, let us say for 45 days. इथर खंडे प्रोड्यूस करिकि बा 2 मास हमें दो 3 मास 2 मास इथर खंडे हां 2 थर ताको प्रोड्यूस करिकि रिपोर्ट आनी देखाम सर जे नॉर्मल कंडीशन ये करिकि लेखन review the report produced by the Land Council for the state as per the previous orders, which shows that there is no criminal antecedent against the petitioner and the petitioner was admitted in the district headquarters hospital on board on 15/9/2025 and she stayed there till 17/9/2025 and during that period her mental status examination was done and the old medical records were also verified and the close relatives were called to obtain a mental history and from the assessment it was found that the mental condition of the petitioner was normal. The report furnished by the Land Council for the state, which was obtained from Senior Superintendent Circle Jail Onwood, is also taken on record. The petitioner is a lady and she is in judicial custody since Kebeto
11/9/2016.
11/9/2016, which was more than 9 years, no? More than 9 years. The accusation against the petitioner is that she threw her 3 minor children into
7 years, 8 months. 7 years, 8 months, 5 days.
କେମିତି?
24/11/17 to
24/11/17
24/11/17 to 2/8/20 ହେଲା।
ଆପଣ ଫାଇନାଲ ରିପୋର୍ଟ ଆପଣ ଭୁଲଭାଲ କହୁଛନ୍ତି। ଫାଇନାଲ ଫର୍ମଟା କହୁଛି 11/9/2016। ସେ ଆଉ କୋଉଠି ଥିବ, ଏଠି ପୁରା ଲେଖିଛନ୍ତି ଆପଣ ସୌଭାଗିନୀ ବେହେରା ତ? ହଁ, ଡେଟ୍ ଅଫ ଫରୱାର୍ଡ ଟୁ କୋର୍ଟ ହଉଛି 11/9/2016। ଆଉ ଆପଣଙ୍କର ଯୋଉ ଇଏ ଦେଖଉଛି accused is produced in custody ତ ବେଲ ଯାଇନି ଆଉ କୋଉଠୁ ଆପଣଙ୍କର ଇଏ ହେଲା? She was never released from bail. ହେଲା, ଠିକ ଅଛି। ହଁ, ଲେଖିବି କଣ ଏଇଟା ବାହାର କର, ସେ ଯୋଉ ଅର୍ଡର ସିଟଟା ପ୍ରିଭିୟସ୍ ଅର୍ଡର। ହଁ ହଁ, she threw her 3 minor children into the well, for which her 3 children died. And the petitioner was also rescued from the well, na?
Yes, ma'am.
Rescued from the well. The land counsel for the petitioner submits that the petitioner, there is no eyewitness to the occurrence.
No,
There is
after
no-
occurrence,
After
occurrence, the father
the eyewitness to the occurrence case is based on circumstantial evidence, and therefore the bail application may be favorably considered. Considering the submission made by the land counsel for the respective parties and taking into account the period of detention of the petitioner in judicial custody, and since the petitioner is a lady, initially the petitioner is granted interim bail for a period of 2 months. No. During the interim bail period, the state superintendent of police on go shall make necessary arrangement to produce the petitioner in the examination at our psychiatric department of the SCB Medical College. Google mark psychiatric department of the SCB Medical Junction twice. And the report shall be furnished by the land council for the state. Out of this matter on 3 months for a pocket, the land council for the petitioner shall produce the surrender certificate, and state council shall produce the so and so certificate.
A copy of the
order will be handed over to sponsor. कोर्ट जेल कितना बनाएगा कि अछंदी जेल सुपरिटेंडेंट कि अछंदी कि अछंदी से कोर्ट
जेल सुपरिटेंडेंट किए अछंती
एंड ऑन म्यूट ही नहीं जरा म्यूट कराई वो जेल से था हाँ क्यों छुआ को मैटर
जेल बने नहीं से आपन ना कोन अछि अनम्यूट करंतु
why are you not passing necessary instruction? Why the Bhagwan? भगवान मोहतर केते नंबर आइटम
आइटम 5
हाँ 5 एटा पर स्पेशल सब जेल बनाएगा एटा कोना से जेल सुपरिटेंडेंट पाखे रहइबो ना
बणेगढ़ से ट्रांसफर जामुझरी की तुम से
अच्छा हाँ ठीक अछि से सुपरिटेंडेंट पाखे रहइबो ना अनम्यूट करना दिसरा
अनम्यूट करंतु
P02 केस हाँ पैराग्राफ 2 टा रे पढ़िले से आसु कनेक्शन दे दुईटा अपन जजमेंट
prosecution case in brief that on 17/4/2011 at about 8:15 a.m.
एटे जणा तो से आसु हाजिर हो आपण
one Okuru Lohar, son of late Sarath Lohar of the village Haladi Kudar, reported in writing at Lohanipada PS stating that on the previous day there was a quarrel between his father and the accused relating with the village tube well. During that quarrel, the accused gave a threat to his father to cause his murder. On the same day in the night time at around 1 a.m. to 2 a.m., the accused forcibly entered inside the house, being armed with a tangia, and brutally assaulted his father, causing his death, while the elder brother of the informant rushed to the spot to save the life of his father. At that time, the accused also dealt a blow with that tangia on him, causing injury on his both big thigh. On receiving such report of the information, IAC Lohanipada PS registered case on such answers, directed to Vishal to take up investigation. During the course of investigation, IO visited the spot, examined the informant and other material witness and the injury Vidyadhar Lohar of his medical examination and the dead body of the deceased.
the council advocate की रमाकांत महापात्र केते वर्ष रहलानी
अनम्यूट करंतु कोंतु अनम्यूट
18
अनम्यूट करंतु
जेल सुपरिटेंडेंट ना होइना दिया को
आपण जेल सुप्रीम डाकंतु अनम्यूट करंतु
अच्छा से भगवान महाकुल तो भगवान महाकुल और सुबुनी ना
आपण भगवान महाकुल तो
जेल सुपरिटेंडेंट किए अछंती कोन आंदी कहीं
ओपन जेल लगी जाम जेल
की
somebody should be in charge of that
अनम्यूट करंतु
अनम्यूट हिसरलाइन से कौन तो लिंक्स चाहिए तो
लिंक
भगवान महाकुल
नहीं आपण कोन ये नेट प्रॉब्लम आसुची भगवान महाकुल आपण पाखर अछंती नेट प्रॉब्लम नेट इकी रमाकांत महापात्र जो जहां को एंगेज कराइतला इकी 5 नंबर देखना
रमाकांत महापात्र
हां हे नाथी एटा पहर दिन को रखुछु आउ ये एडवोकेट की जानी नहीं रमाकांत महापात्र की
ସାର୍ ନମସ୍କାର।
ସେ ଭଗବାନ ମହାକୁଡ଼
ଆଜ୍ଞା ନମସ୍କାର।
ହଁ ଆପଣ କେତେ ବର୍ଷ ହେଲାଣି ରହୁଛନ୍ତି ଏ କେସରେ ଆପଣ ଭିତରେ ଫାଇନାଲ
15 ବର୍ଷ ହବ ବେଟିଟିକୁ
15 ବର୍ଷ ହେଇଗଲାଣି
ଆଜ୍ଞା
ନା 14 ବର୍ଷ?
15 ଚାଲିଛି।
18/4/2011 ପରେ ଆଉ କେବେ ବେଲ୍ ଯାଇନାହାନ୍ତି?
ବେଲ୍ ଦେଇଛୁ 18/4/2011 ପରେ ବେଲ୍ ଦେଇଛୁ? ନାଇଁ ଆଜ୍ଞା ବେଲ୍ ନାଇଁ ଯାଇ।
ଆଚ୍ଛା ଆପଣ କୋଉଠି ଥିଲେ ଆ ପୂର୍ବରୁ? ଏଠି ତ ଜାମୁଝରରେ ବର୍ତ୍ତମାନ ଅଛନ୍ତି, ତା ପୂର୍ବରୁ କୋଉଠି ଥିଲେ?
ନାଇଁ ଜାଗା ଥିଲି ଆଜ୍ଞା।
ଓହୋ କୋଉ ଜେଲରେ ଥିଲେ?
ସାର୍ ବଣେଇ ଜେଲ୍। ସାର୍
ଆଁ?
ସବ୍ ଜେଲ୍ ବଣେଇ।
ଆଚ୍ଛା
ସବ୍ ଜେଲ୍ ବଣେଇରେ ଥିଲି।
ସେଇଠୁ ଏଠିକି ଆସିଛନ୍ତି ଜାମୁଝରକୁ?
ସାର୍
କେବେଠୁ ଏଠିକି ଆସିଲେଣି ଜାମୁଝରରେ?
3 ବର୍ଷ ହେଲା।
3 ବର୍ଷ। ଆଉ ଘରେ କିଏ ସବୁ ଅଛନ୍ତି?
ଘରେ ଭାଇ ଅଛି। କିଏ ଅଛନ୍ତି କୁହ? ଭାଇ ଭଉଣୀ ଅଛନ୍ତି। ସାର୍ ସେ କହୁଛନ୍ତି ତାଙ୍କର ଘରେ ଭାଇ ଆଉ ଭଉଣୀ ଅଛନ୍ତି।
ଆପଣ ଆପଣ ବେଲ୍ ଦରଖାସ୍ତ ଦେଲେନି କାହିଁକି? ଦଉନାହାନ୍ତି ଆପଣ? ଏ ରମାକାନ୍ତ ମହାପାତ୍ର ବି appear କରୁନାହାନ୍ତି। somebody should file a bail application ହିଁ ନାହିଁ।
2016 ପ୍ରିଜନର ପିଟିସନରେ ରମାକାନ୍ତ ମହାପାତ୍ର ନାଁ ଦିଆଯାଇଛି। 2016
ସିଏ ନିଜେ ଦେଇଥିଲେ?
ଏଇଟା ସବ୍ ଜେଲ୍ ବଣେଇରୁ ଆସିଥିଲେ।
ରମାକାନ୍ତ ଆପଣ ଯୋଉ ଲେଖିଥିଲେ, ଯୋଉ ଦରଖାସ୍ତଟା ଦେଇଥିଲେ ଯେତେବେଳେ ସ୍ପେଶାଲ ସବ୍ ଜେଲ୍ ବନାଇ ଗାଁରେ ଥିଲେ, ଆପଣ ଲେଖିଥିଲେ ରମାକାନ୍ତ ମହାପାତ୍ରଙ୍କୁ ମୁଁ ଓକିଲ ନିଯୁକ୍ତି କରିବାକୁ ଦିଅନ୍ତୁ ବୋଲି। ତ ରମାକାନ୍ତ ମହାପାତ୍ରଙ୍କର ନାଁ ମଧ୍ୟ ଆଜି ଲିଷ୍ଟରେ ଅଛି। ସେ ରମାକାନ୍ତ ମହାପାତ୍ର କୋଉଠିକାର ଓକିଲ? କଣ ଶୁଭୁନି ତାଙ୍କୁ ନା କଣ?
ଉତ୍ତର ଦିଅନ୍ତୁ।
ନାଇଁ
ସେ କହିବେ ନା, ସେ ନିଜେ ଦେଖିଥିଲେ ତାଙ୍କ ତ ସେ ଲୋକାଲ କାଉନସିଲ ହେଇଥିବେ, ସେ କୋଉଠୁ ଆଫିୟର କରିବେ?
ଆଡ୍ରେସ କିଛି ଯୋଉ ରମାକାନ୍ତ ମହାପାତ୍ର ଲେଖା ହେଇଛି କିଛି
ପ୍ରିଜନର୍ସ ପିଟିସନ ଅଛି ପରା, ସେଇଥିପାଇଁ ନା ରିଫ୍ଲେକ୍ଟ କରାଲା କ୍ଲଜ ଲିଷ୍ଟରେ। ସେ ଯଦି ତାଙ୍କର ସେ ଲୋକାଲ ଗାଁର ସେ କାଉନସିଲ କିଏ ହେଇଥିବ, ତାକୁ କୁହନ୍ତୁ ଆଉ ଥରେ ଡିସକନେକ୍ଟ କରି ଲଗେଇବା ପାଇଁ। ଫୋନ୍ ଫାନ୍ ନମ୍ବର ନାହିଁ କି ଆପଣଙ୍କର? ଆଉ ଫୋନ୍ ଆଣି ଦବୁ। अच्छा वकालतनामा फाइलिंग। You do one thing, you collect one वकालतनामा। से ता ना भी वकालतनामा ही नहीं, ये लिखिदेले प्रिजनर्स पिटिशन ने ସେଇଥିପାଇଁ रिफ्लेक्ट ହେଇଗଲା। वकालतनामा कलेक्ट करनी हूँ काहाकू जन को एंगेज करे देकिनी ये बेल एप्लीकेशन दिया हो है ना। लिखी दियो आइटम नंबर 5 नॉन appears अगर stop. It appears that on the basis of prisoner's petition, one Mr. Ramakanta Mahapatra was engaged as the counsel for the appellant. No wakalatnama is available on record. Since the prisoner's petition was sent from special sub-jail Bonaigaon, we asked the London Council for the state to ensure the appearance of the appellant to virtual mode from the said jail. However, the learned counsel for the state submitted that the petitioner is now lodged in open jail na kaun seda kouchen
Jamujari. Biju Patnaik
Biju Patnaik open ওটা দেখি লিখবে open jail Jamujari na the petitioner the appeared to virtual mode stop. From the records, it appears that the petitioner was taken into judicial custody on 18/4/2011, and thereafter he was never released on bail. The appellant also submitted that he has never been released on bail after being taken into judicial custody. The land counsel for the since the land counsel whose name has been reflected in the prisoner's petition is not appearing, let the land counsel for the state obtain the wakalatnama of the petitioner so that a counsel from the High Court Legal Services Authority can be engaged for the appellant. Put up this matter. এটাকু 27 তারিখে রাখুଛୁ আপনার নিয়ে আসুন this matter on 27th of October 2025 বাকি যেটা রইলা day after tomorrow আসছে না tomorrow there is another bench madam this bench is not there.